State Medical Board of Medical Licensure full board meeting of November 19th, with resuming the meeting that started yesterday. We will start with Agenda 16, hearing in the case of Elaine Reinhardt, MD, Brookhaven, Mississippi, Mississippi Medical License number 17415.
Can y'all hear me fine? Okay, good. Mr. President, board members, this is a hearing in the case of Dr. Elaine Ruth Reinhardt. I'll provide a little summary of the background in just a moment, but before we proceed, I see that she's not here. May I ask Jonathan Dalton to step outside and confirm that she's not here? Dr. Reinhardt. She is not here. May I proceed?
You may.
Let the record reflect that Dr. Reinhardt is not here. We're going to proceed in abstention. Please place into the record, as I summarize the facts of this case, but to be brief. In July of last year, 2019, Dr. Reinhardt came under investigation by this board for prescribing controlled substances outside the course of legitimate professional practice. To avoid a hearing, she executed a consent order on October 29 of 2019, which basically addressed the prescribing, provided for CME, but most importantly, the board felt that there was an issue that she probably would benefit from a comprehensive evaluation at the Mississippi Physicians Health Program. The consent order, which I will place into the record, stated that she should immediately make contact with the MPHP and seek an evaluation for mental, physical, or any other issues that might create an impairment situation. She executed that consent order and the board approved it on November 14, 2019. On January 27, 2020, the board was advised by Dr. Hamilton that Dr. Reinhardt never contacted the MPHP. A summons affidavit was thereafter issued on June 9, 2020, calling her before the board and charging her with failure to comply with the terms of the consent order, which she freely acknowledged and executed. I'm going to place into the record a series of emails and communications between my office, this board, and Dr. Reinhardt's attorney, Greg Malton. He made substantial efforts to try to get her to respond and to come before this board and to, most importantly, to make contact. She did make contact at one point with Dr. Hamilton, but at that point never officially took the steps necessary to meet and to submit for the evaluation. She did, however, on August 25, 2020, in an effort to get a continuance, which is board granted, she executed an agreement not to practice medicine. The problem with that is that this thing has been on the docket now for 3 months, well, almost 6 months, and almost a year technically. And you just can't keep an item in abeyance such as this. So at the last board meeting on at the September 17, 2020 board meeting, the board granted her a second continuance and made it very clear this is the last continuance. No other continuance will be granted. And again, encouraged her to contact Dr. Hamilton in the program and take the steps necessary to be evaluated. She has failed to do this. And so that's the reason why we're proceeding today. And we're going to go ahead and proceed in absentia. The board had corresponded with her attorney, Greg Malta, and stating that we would like to hear it on Wednesday. He could not get in contact with her, and so out of abundance of caution, the actual order of continuance entered back in September called for this matter to be heard today. And so just again, out of the abundance of caution, as an officer of this court or this tribunal, I contacted Greg Malta this morning. I said, Greg, we kicked it to this morning. Is she going to be here? He says she's got notice. I don't think she's going to be here. I've done all that I could. So I would like to introduce as board exhibit number 1, the consent order, which Dr. Reinhardt executed with this board on October 29, 2019. As board exhibit number 2, I'm going to place it to the record the summons and affidavit issued June 9, 2020, charging Dr. Reinhardt with violation of the terms of the consent order, which I just mentioned. Board exhibit number 3, I'd like to introduce as a composite exhibit copies of the multiple emails to and from Attorney Greg Malta, the attorney for Dr. Reinhardt, wherein he clearly documents his efforts to communicate with her, and the emails to and from the MPHB advising this board of her failure to do what the consent order requires. That'll be board exhibit number 3. Board exhibit number 4 will be the August 25, 2020 agreement not to practice. Mr. President, may I introduce these to the record, please?
Yes.
I will say again, even though she's prohibited from practicing, this is an item that we just can't keep on the docket ad infinitum. And so the board made the decision, we're gonna have a hearing today, and so that's why we're here. And I'm gonna go ahead and tender these to the board and let the board make a decision as to what it wishes to do. Out of an abundance of caution, let me call Dr. Scott Hamilton just to confirm the fact that he's made an effort to communicate with her. Please go ahead.
If I could interrupt for 1 second, just wanted to make a reminder to the board members whenever we start to speak, just because of the mask and difficult to communicate, to try to raise your hand, identify yourself before you speak. Thank you.
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
For the record, if you'd state your name, please.
Scott Hamilton. I do.
And your position.
I'm medical director of the Mississippi Physician Health Program.
Are you familiar with the respondent in this case, Dr. Reinhardt?
Yes.
Very briefly, she's not here, but very briefly, would you please explain to the board the steps that you've taken as a medical director of the MPHB to encourage and to seek the cooperation from Dr. Reinhardt?
Yes. I began communication with Dr. Reinhardt in early July. I scheduled a Zoom video conference with Dr. Reinhardt on July 20th. And later that day, I emailed her information for several facilities that could perform a comprehensive fitness for duty evaluation. She agreed to do this. And then after that, communication with her basically ceased. Ultimately, I had to send a letter to an email to Dr. Cleveland on August 21st, informing him about my concerns about her current state and her failure to comply.
Of course, with the limited understanding that you have, what is your concern as to her mental state?
I have concerns that she may have an untreated and undiagnosed psychiatric disorder or substance use disorder.
Do the board members have any questions? Thank you. Once the board members have some questions of me, I tender the case to you for your consideration.
I move we close the meeting in order to go into executive session.
Is there a second?
Second.
Any discussion? All in favor, say aye.
Aye.
Any nays? To the room. will stand.
Where is she? I think she was doing expert testimony. This thing on the overway? Yes. He does. I told him I'll never back. I think he's talking with the defense attorney for the back here. There might be some kind of bullshit going on. So ultimately,
Board's now back in open session. Board unanimously voted to revoke the license of Dr. Elaine Reinhardt, Mississippi Medical License Number 17415.
Thank you.
Moving on to agenda item number 18, hearing in the case of Joseph Jackson, MD, Biloxi, Mississippi Medical License Number 08636.
All right.
Out there.
Let me go check and find out where opposing counsel went.
Well, I'll just prove that's not a good thing to do. you're ready right now.
Right.
At least that was during the opening statement.
Certainly had drama.
For that matter, I better make sure mine's turned on. Yeah, it is. I'm trying to read. Y'all ready? Okay. Okay. Mr. President, board members, I want to introduce Dr. Joseph Allen Jackson. Representing him is Michael Crosby. And we're ready to proceed. I think we do a little housekeeping if we may. I'd like to go over some of the documentation that I want to introduce into the record, some of which we'll introduce now, and then other documents we'll introduce as I question Dr. Jackson.
Thank you, Stan. And for a measure of legal expediency, our Assistant Attorney General, Alexis Morris, will be administrating this hearing.
Thank you. May we proceed?
Yes, please.
What we have here today, board members, is a hearing in the matter of Dr. Joseph Allen Jackson. Dr. Jackson practices or practiced out of, I believe it was Gulfport or Biloxi. And he was charged a number of months ago with multiple violations of the Medical Practice Act. Before I do my opening statement, let us go ahead and do, as I said, some housekeeping and introduce some documents to the record. As board exhibit number 1, I'd like to introduce just certain copies of the pleadings in this matter. You will notice there's an amended affidavit, and there's a reason why we amended it to streamline some of the accusations and to, quite frankly, to eliminate some textual statements that we felt were a little bit, not inflammatory, because they're straightforward, but just to simplify the charges. Because as I will state in a few minutes ago, one of the primary allegations against Dr. Jackson is professional sexual misconduct, and let the record reflect that as opposed to the original affidavit. So the amended affidavit, along with the responsive pleadings and some of the discovery requests, will be introduced as board exhibit number 1.
Hello, everybody. My name is Michael Crosby, as Mr. Ingram introduced me. I would ask for the original complaint to be redacted from this document because of the inflammatory and unfairly prejudicial accusations in that complaint. The amended complaint took care of that, and I believe that that is the instrument upon which we are proceeding. I don't see it being necessary or relevant to have the original complaint because it would only cause those issues to rise. So if we could redact that complaint, then I would not have an objection to the amended complaint as Mr. Ingram now.
Well, let me respond, but I've already addressed that situation. I don't consider it inflammatory when you have sex with a patient and you send text between each other, which basically substantiates that romantic relationship. I don't consider that inflammatory. Now, they may, just to avoid a public record that because this hearing is a public record, and so it's going to come in. But I do not have the original affidavit in here, just the amended affidavit, and the board can hear the evidence as we proceed. Do you have any objection? I do not have the original affidavit in here.
if the original affidavit's not in there, I thought it was all the pleadings. If the original affidavit's not in there, then that would take care of my objection.
Like we say, yeah,
Please.
this will be board exhibit number 1. Just for the record, to show that Dr. Jackson is duly licensed to practice medicine in the state of Mississippi, board exhibit number 2 will be his application for a Mississippi medical license.
And no objection.
Exhibit number 3 will be copies of 2, what we refer to as warning letters issued to licensing. That's a very common practice when you have an investigation and the matter does not result in disciplinary action. Oftentimes, the matter is resolved with a warning letter from this board. And these are 2 warning letters, one dated March 2, 1995, and the other November 25, 1996.
And no objection.
Number 3, I think. Board exhibit number 4 will be certified copies of Dr. Jackson's registration as a pain management clinic. And a letter dated March 23, 2020, where he advised this board that he was ceasing or discontinuing his pain management practice.
No objection to the document.
Board exhibit number 5 is a copy of an email, certified copy of an email from Dr. Jackson to DEA, where he says, I retired from the active practice yesterday, June 9, 2020, relinquishing his DEA number at that time.
No objection.
For exhibit number 6 will be the electronic medical record for patient TL. It is, there are actually two copies of this particular document. I'm including page 1 from page 1 through 164, 165. And these are electronic medical records. And before I go any further, this board is not concerned with the identity of patients. We're concerned with the quality of medical care. And so you're going to hear testimony from the board investigators, experts, and so forth, and me. We're going to refer to this patient as TL, or refer to it as patient, because there's only one patient involved in this case. And so I'm going to ask the board members, if you ask questions, please, and the documents will reflect his identity, but we're going to ask that that identity not be revealed, and then ultimately these items go into the record, especially if they go up to Chancery Court on appeal, that we will redact the man's name and refer to him as patient TL. Any objections?
Oh, no objection.
That's number 6. Exhibit number 7 will be the originals of the prescriptions issued by Dr. Jackson to patient TL. between two dates, during the time period in which he treated this patient, from October 2017 through July 2019.
No objection.
What number?
8.
8. All right. As board exhibit number 8, I have a spreadsheet representing data, prescription data obtained from the Mississippi Prescription Monitoring Program during the period of time in which Dr. Jackson treated patient TL.
No, this, I believe, will be probably our only objection. And the reason we're objecting to this is that the Mississippi Prescription Monitoring Program guidelines are set forth in 3 pages. And of course, they're published on the internet, on the website of the medical board. And on page 2, in the second full paragraph, it very clearly states that the MSPMP report is a tool and shall not be used in court. And as such, I would object to it being used in this court proceeding. And by its own terms, it excludes itself. So that would be my objection to the contradicting the explicit words of the rules and guidelines that are published and upon which the physicians operate. I do anticipate a possible counter to the argument that in a different case, under different circumstances, a federal judge named Judge Ozadun had overruled this objection that I made in that proceeding on the basis that these are state guidelines, and the judge on the record very clearly told me that we were in federal court, not state court, and that he would proceed under the federal court rules in his court and would not give any consideration to state court rules. And my issue is that the PMP are generated pursuant to the guidelines set forth in the state. And if the state and the guidelines themselves do not consider them worthy as evidence to be used in a court proceeding, then it should not have been used in any court proceedings, even though the federal rules might allow them. But of course, we are in a state court, and I would respectfully submit that the state court rules apply here. Even though we do have some admissibility issues as far as hearsay and other things are relaxed in these proceedings, but we cannot get around the fact that it is very clear, specifically states that it shall not be used in court.
Counsel, do you have a response?
May I respond?
Yeah.
Yes, thank you. First of all, this is not a court of law. This is an administrative proceeding. And the board has already, on multiple occasions, permitted introduction of data and printouts from the Mississippi Prescription Monitoring Program. So this is nothing new to this board. Secondly, the whole purpose for that statement in there is because sometimes you have to have, I'm assuming that prohibition deals with introduction of the data from the PMP without any supporting collaboration. I will introduce, and I've already introduced, the actual prescriptions, the original prescriptions. So the data set forth in this spreadsheet is supported by the actual prescriptions that we have placed into the records. And so that creates the reliability of the document. Second, well, not finished. Also, the case which opposing counsel references is a federal criminal case. Those guidelines do not say federal court, state court. It says court. And the U.S. District Court for the Southern District allowed similar type prescription monitoring data to be introduced based upon a hearsay exception. Now, hearsay exception means it's reliable. Again, the reliability of this data is clearly supported by the fact that the original prescriptions have already been introduced. And again, I point out this is an administrative proceeding. It's not a court of law. The rules of evidence are not strictly applied. And hearsay is permissible within reason. But more importantly, this board has allowed PMP data to be introduced multiple times through many, many years. So this is nothing new.
Mr. Crosby, while I note your objection, I'm gonna overrule it.
What prescription, what exhibit number? Okay, that's for exhibit number 9. Will be a witness affidavit from Stephanie Bueller, who is the executive director or works for the Mississippi Prescription Monitoring Program, certifying the number of times which Dr. Jackson accessed the PMP during his treatment of patient TL.
That would just simply be the same objection that you've already wrote on, Your Honor. Could I put just real short into the record my response that was not there before? I did not, you ruled, and I never tried to argue a ruling, but I should make the record if it's okay.
Continue.
With respect to the multiple times that the PMPs have been used before, I would state that we don't know what objection, if any, was made at that time. So we do know it was made here. As far as the statement that hearsay, if there's an exception to the hearsay rule that makes it reliable, well, there may be an exception, but whether it's reliable or not would be up to the fact finder, just because something's allowed. So that's not necessarily an agreed statement, but we don't necessarily agree with that. The idea that this is not a court, well, it's certainly, we don't want to get into a debate over the definition of the word court, but it's definitely in line with court proceedings. And being that this is appealable to Chancery Court, with undisputably a court, then you would be introducing evidence here that a court could not consider. And if your decision is based in part upon inadmissible evidence, then that would create a problem, and therefore we must consider this to be a court as intended by the guidelines. And then finally, the statement that is supported by other evidence, well, that would be another reason why it would not be admissible. If you have other evidence, then that evidence speaks for itself and would not make it necessary or relevant to put in the inadmissible PMPs. But I just want to have that for the record. Thank you.
Thank you.
For exhibit number 9. I may have some other exhibits to introduce as I proceed. Also, I think for the record, I'm going to place the board takes judicial notice of its own rules and regulations. But as the testimony will reveal, as many of you board members who were then on the board can recall, during 2018, the rules and regulations of the board pertaining to the prescribing, administration, and dispensing of controlled substances was changed. And the rules that required pain management clinics and doctors who prescribe controlled substances, narcotics, opioids, must access the PMP at every visit went into effect October 28, 2018. Prior to that, you had to access the PMP on the initial visit and at reasonable intervals after that. On October 28, 2018, Dr. Jackson was treating patient TL. And the record will reflect, as I indicated, already introduced, multiple instances where he failed to make contact with the PMP to check. Just for the record, I'm going to introduce the rules and regulations and the Secretary of State filing showing where these rules went into effect October 28, 2018.
Okay. I took that out of place, so I left it over here.
That's all right, that's all right. I'll take it over there. There may be other exhibits, and I'll introduce those as we proceed to the hearing. Do you have any exhibits you want to introduce?
No, I believe that our exhibits will be contained within those.
Just as a matter to expedite the process, can we get any witnesses sworn in at this time?
Miss Betty. I'm just gonna swear you in.
That's all.
Any potential witnesses? Court reporting, please.
Yeah, yeah, well, yes, I plan to call you the witness.
All right.
Okay. Ray Bell, Harry Gunter, my God, and then my expert, Dr. Randall Sherman, Dr. Jackson, and please identify yourself. I know who you are. But
Betty Matthews.
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Would any of you like to invoke the rule before we begin?
I don't necessarily need to, but that's not my call, solely my call.
Not at this time, yeah.
Proceed when ready.
May I proceed with an opening statement?
Yes, sir.
And then obviously opposing counsel will do the same. A lot of paperwork involved here. All right, what we've got here is a hearing in which Dr. Jackson has been charged with five counts of violation of the Mississippi Medical Practice Act. First is being guilty of unprofessional conduct, including being guilty of any dishonorable or unethical conduct likely to deceive or cause harm to the public. The main thrust of that is professional sexual misconduct and prescribing outside the court. Count two, guilty of administering, dispensing, or prescribing any narcotic drug or other drug having addiction forming or addiction sustaining liability. The evidence will show that because of his romantic relationship with patient T.O., Dr. Jackson failed to exercise objectivity in how he treated this patient and what he prescribed. Even if we exclude the sexual misconduct, how he treated the patient is outside the course of legitimate professional practice, as the evidence will reveal. Count three, failure to comply with Rule 1.4 maintenance of records as a result of licensee's failure to document in the medical record a written treatment plan and objective measures of successful treatment. Count number four, violation of Rule 1.3 and 1.14 of the rules and regulations of the board as a result of Dr. Jackson's failure to query the Mississippi Prescription Monitoring Program, as he was required to do because he was practicing, number one, prescribing opioids and other controlled drugs. Number two, was a pain management clinic at the time. Count number five, violation of Rule 1.4 patient record as a result of failure to register and to enter into the record on numerous occasions prescriptions for controlled substance issued to the patient, TL. Now, I'll try to be brief. At all times, when Dr. Jackson was treating patient TL, there was a romantic relationship. In fact, Dr. Jackson, through my correspondence and discussions with opposing counsel, is not denying that he had a romantic relationship with patient TL. Let's get that on the table now. He provided money and his credit card to said patient. Now, as I go back, I'm going to say these are boundary issues. Even if you took the sex out of it, these are other boundary issues that destroys that objectivity I'm talking about. Providing money and his credit card to patient TL, text conversations of a sexual nature. Providing the patient with his email address, his phone number, and his Florida driver's license to allow him, the patient, to purchase items, apparently. And as detailed below, prescribing controlled substances outside the course of legit professional practice. Paragraph 8 of the complaint, or the amended affidavit, states that during the treatment period, October 2017 through July 2019, he provided patient TL with 1,304 controlled substance pills, along with 120 cc's of or liquid medication. The pills are buprenorphine, clonazepam, dextroamphetamine, oxycodone, and tramadol. The injectable medication or liquid was depo-testosterone, testosterone CYP 2,000 milligram, 10 milliliter, and testosterone CYP 200 milligram per milliliter. Total of 120 cc's in that regard. I think I'm pronouncing that correctly. From the very beginning, Dr. Jackson was put on notice that this man had a drug problem. The very first entry, which states, "Why are you here?" He says, "I'm a drug addict." It goes through an elaboration of, and I'll go through that in just a few moments with the good doctor. Despite saying that he's not actively using opioids, on the very day that he sought treatment, he acknowledged that he'd taken opioids. The evidence will show that the doctor prescribed substantial amounts of testosterone and similar medications without conducting the first laboratory test to confirm the low testosterone. He diagnosed low testosterone, but you're not going to see any lab reports or diagnostic testing of that file. He prescribed during the profile period Adderall to this patient. Nothing in the medical record which shows any diagnostic test that you normally, the practitioner would normally run to substantiate the diagnosis of ADHD. Yet he prescribed substantial amounts of Adderall to this patient. And in many cases, the patient asked for it. In many cases, the patient testimony will show that the patient one day wanted the Adderall, or one day he wanted the buprenorphine to get on, as he called it, the program. And even though he was warned correctly by Dr. Jackson that I'm not going to give you opioids at the same time I give you buprenorphine, he would switch. One moment he's prescribing the opioids. 2 weeks later, he's going back to the program getting buprenorphine. A week or 2 weeks later, he's going, or a month later, he's going back to using opioids. So there's no consistency at all. The patient made a request and the doctor responded by prescribing what the patient wants. see into the record a text where he's corresponding, texting with this patient, talking about some money and so forth. He says, "Oh," in the Adderall. That's how the patient asked for what he wants. He was telling the doctor, "Oh, by the way, I need my Adderall." The doctor gave him to him that day, and that prescription was 10 to 11 days premature. In other words, too early. He gave it, and that's one of the criteria that the board uses when deciding whether or not prescribing is outside the course, or is the doctor issuing prescriptions at a time when the previous amount has not been properly consumed if the patient's taking the medication. You'll hear testimony on multiple occasions where the patient is coming back acknowledging he took more than he should. And yet the program goes on, then at one moment he stops the program, the next moment he's prescribing opioids again. The patient records will reflect, as I said, failed to document proper PMP. In fact, during the prescription profile period, he accessed PMP only 3 times. Only 3 times. And after the rule went into effect, October 28, 2018, he only checked it once. Finally, there's 1, 2, 3, 4, 5, 6 prescriptions that were written during the profile period, which there's no entry in the medical record to substantiate why he issued the prescription, or there's no evidence in the record to show you that he even issued that prescription. So basically, the evidence will show that Dr. Jackson not only is guilty, and he admits that, to professional sexual misconduct, but has prescribed controlled substances outside the course of legitimate professional practice.
Ladies and gentlemen, obviously, this is a troubling situation. And can I ask if I could take my mask off while I'm speaking from this distance? Is that okay? That's how we do it in the courtroom. I didn't know if it would be appropriate here.
Are you acknowledging this as a courtroom?
Definitely. Dr. Jackson was humiliated by his own behavior and by his own admission. And it's really sad that we come here because you're going to have a brilliant physician with impeccable credentials who had a long and distinguished career, highly reputable in his community and among his peers. And then he fell in love with someone, not his wife at the time. Dr. Jackson has been married to the same woman for a very long time. And it's not necessary to get into the nature and the problems associated with their marriage, where it went the nature of it turning into more of a friendship. But the problem is Dr. Jackson fell in love. And he fell in love with someone who proved to be a con artist, a masterful con artist, who had this set up from the beginning. It will be overwhelmingly clear it was set up from the beginning. And there was a business relationship outside of the physician-client relationship by the doctor's admission and acknowledgement. And then it was a construction company, and there was money and credit cards used in that business. So there's no dispute over Dr. Jackson giving TL access to money to be able to purchase materials and such as that. But Dr. Jackson is ready to acknowledge his error. He has stopped practicing that pain management as acknowledged by the letters. And the DEA, of course, issues a license that allows you to prescribe certain medications, including pain medications, Schedule II and others. And you have to have that license. But he, as the letter in the exhibit indicates, he notified the DEA that he would not be doing that in Mississippi pursuant to the letter now in evidence. he has focused and started focusing on the addiction aspect of the practice of medicine. Definitely, he had a pain clinic, but he also operated an addiction clinic. And his son came into the practice and took over the pain management part. And Dr. Jackson handled the addiction part of it. TL's first visit, as you'll see, where he came in and said that he was using medication, he filled out the application, but he was not treated at that time and was not being seen at that time, but he applied to be a patient there pursuant to the addiction part of the practice. And so when he said he used medication, it's going to be clear that, or he was taking pain medication, that at the time he was treated, he was off of medication, as the record should show, and Dr. Jackson will testify. So we have a little bit of a difference of opinion about that. We also have some difference of opinion about what was said and the number of prescriptions and what was done in that respect, but Dr. Jackson will address those issues. It's humiliating to see text messages of his relationship, especially now that he knows he was being deceived and conned in that relationship. But the evidence is going to show that Dr. Jackson not only has stopped practicing in certain areas of medicine, in most areas of the medicine as he previously did, but he's also getting treatment by a psychiatrist. And he's been getting counseling for that, so he can try to understand how he made these mistakes towards the end of his practice, so he can make sure that he understands what was wrong with his judgment, why it was impaired, and how to go about solving that problem. And so on his own, he's undertaken those measures to solve the problem that he recognized that he had a definite error in judgment and a problem there, and to allow himself to be deceived. But that is the nature of love. That's the problem with love, is that it causes some people to do things that you would never expect. But overwhelmingly, you will see that Dr. Jackson, despite the fact he absolutely should not have treated his person with whom he had a relationship, what he did was actually correct. He did apply the proper medicine in that respect. There is, to the extent that we have other issues, like, for example, Mr. Ingram describing the TL asking for a particular medicine, which should be, in some instances, a red flag. But if that person's already getting that medicine and the doctor is filling out the prescriptions, then it's not so egregious if the patient reminds the doctor that, well, you left off the medicine that I've already been taking, that needs to be on there too, during the conversation. So it's a little taken out of context. It could look like a red flag, but not. So I simply ask that you recognize that we have a difference of perspective about certain statements made that were out of context. It has been, there's no way to get around the fact it's been horrific, what the doctor has been through. But I'm expecting that he's going to be the very first witness that's going to be called. And I think it's better for you to hear it straight from the doctor. So with that, we're ready to proceed.
I would like to call as an adverse witness, Dr. Jackson.
Dr. Jackson, if you would just tap it a couple of times, make sure it's on. Okay.
Can you please state your name for the record?
Dr. Joseph Allen Jackson.
Where are you currently living?
I am living in a retirement community in Spanish Fort, Alabama.
Now, how long have you been licensed to practice medicine in Mississippi?
I didn't figure the specific date. I got originally licensed in 1979. think that's like 41 years, but I'm not sure.
Now, you're certified in neurology and psychiatry?
I boarded at 8 different boards. My primary board was neurology, and I also was boarded in psychiatry. I am boarded in sleep disorders medicine. I am boarded through neurology for pain. I am boarded by a board for nerve conduction EEG, for neuromuscular diseases. I'm boarded in another board that is for evoked potentials in EEG, and I'm also boarded in medical acupuncture.
Medical acupuncture, now. All right, board members may want to know, what boards are you referring to for each one? Is that the,
I'm sorry,
is that AMA recognized boards you're referring to?
most of those are recognized by the AMA, but I don't know. I didn't bring that kind of information with me.
There's a lot of entities out there that say, you know, you sign up with us, you're boarded. I just want to make sure.
No, these all require examinations, most usually comprehensive written and orals.
Are you board certified in pain management and addiction medicine?
Addiction, no. Pain, yes.
Now, you heard the allegations set forth in the 5 separate counts. At the outset, I just want to get it on the table. You're not denying the fact that you entered into a romantic relationship with a patient, TL.
I am not denying the romantic or business relationship that I have with him.
Also, before we get into that in more detail, have you ever been investigated by this board before?
Not that I knew of. Y'all sent me information about 2 times. I remembered when I got that about someone coming down one time about a prescription I was writing for the mayor of Long Beach at that time. And he had been getting more than he should have. And we stopped that.
Yeah, I'm going to present, now approach the
Yes.
witness. I'm going to present you 2 different letters, if I may. Go ahead. The first is dated March 2, 1995. What was the nature of that? Do you recall that warning letter?
Oh, yeah. I don't think you sent me this. 2 patients had been sent to me by a local doctor on Friday afternoon at 4 o'clock that were in active opiate withdrawal. And I wrote 2 total, 2 methadone for pills to get them by until they could get to a methadone clinic. That was documented, and there was nothing else that occurred from that. A total
So
of 2
basically,
pills.
you got a warning letter from the then executive director, I think it was Tom Stevens,
Right.
that you can't use methadone for that purpose.
I knew I could not use methadone for withdrawal. I was not attempting to. I was giving a dose of methadone compassionately so they could get to a program that did provide that. At that time, there were no programs, at least not in South Mississippi. So they had to get either over to Mobile or New Orleans. And it was a total of 2 pills.
You received another warning letter on November 25, 1996, is that correct?
I'm not sure if this is the one that came related to the prescriptions for the mayor that I had been writing for Furostat, but time-wise, that must, oh, there it is, I see it now. Yes, this is about the Furostat prescriptions.
What was Dr. I think it's Stevens, what was his warning to you about? He says, I strongly encourage. What did he tell you?
Which paragraph?
Third one down.
He said, you want me to read it?
Please.
I strongly encourage you to evaluate the needs of your patients for controlled substance and other highly abused drugs such as Furostat, and make certain these patients / and or friends do not use you to obtain these drugs.
Thank you. So Dr. Stevens was saying, why do you think he would say, don't prescribe, or be very careful when you prescribe to a friend? Why do you think he would say, tell that to you?
Yeah, objection to speculating what someone else thinks. That would be an inadmissible request for him to speculate as to what's inside the mind of somebody else.
In your opinion, why would it be suspicious or have to be very careful before you prescribe to a friend? Why would that be the case?
Well, you do realize Gulfport is not that big, and most of my patients, at least probably a third of them, were friends. So yes, I think you always have to be a bit concerned if it's a friend that you trust them more than you should. And unfortunately, I do trust people more than I should. So I thought that was an appropriate warning to me.
And do you think that you adhere to that in the case of patient TL?
No, I did not.
Now, exhibit number 4, you were issued a pain management registration certificate beginning back in 2017, I think it was. Yeah. So how long did you practice, did you maintain a certificate to operate a pain management clinic? Do you recall?
We had it at the time that I closed the office down. So from whatever that date was in 2017 until we closed it in 2020, I stopped doing pain management in 2018 when my son came into the clinic, primarily because I had a slight tremor and could no longer really do injections.
But you were still treating patient TL in 2018, so you didn't stop as to him.
I did not stop the Suboxone part of my practice, which I continued until I retired.
Are you saying that effective 2018, we wouldn't find any opioid prescriptions to patient TL?
Yes, you found a few after he had been accosted and hit in the head, but no, not primarily. He always kind of bounced in my mind between being a pain patient and being an addict. Over the course of time, it became very clear that he was primarily an addict.
On March 18, 2020, you corresponded with the board. It says, this letter is to officially notify you of my intent to discontinue the practice of pain management effective immediately. Therefore, we have begun the process of transitioning all pain patients to other clinics. Is that correct?
That is correct. My son had decided that he was no longer willing to do that after all the stuff that had happened. And in fact, we separated ways. He continued the clinic and I retired.
Are you saying then that effective March 18, 2020, since you discontinued your pain management practice, try not to duplicate, that's when you stopped treating pain management for TL?
Now, he had not been seen since June of 2019. You know that.
You were treating this patient, TL, on March 18, 2000. Oh, I'm sorry, this is 2020. Fire. Now, you also corresponded with DEA on June 9, or effective June 9, 2020, stating that I retired from the active practice of medicine. Is that correct?
That was my last day of actually seeing patients. And I knew that I was going to move out of the state of Mississippi. And I knew that all of this was going on. And I did not want to have a DEA. So I would never again be put in the position of having to make these kinds of decisions or choices.
So what prompted your decision to retire your DEA number?
I did not want to write any additional class drugs in the state of Mississippi.
With the fact that DEA had executed a search warrant of your clinic on March 10, 2018 have anything to do with it?
That's why my son decided he didn't want to continue practicing pain management. And that's why I decided I had had enough of this and did not wish to continue.
Let me correct. The DEA search warrant was executed on March 10, 2020. Is that correct?
I don't know the date, but it was in March.
Okay, 2020.
Yes,
Shortly after that, that's when you sent this email to DEA. It says, I retired from the active practice yesterday, June 9, 2020, correct?
at the time, we decided not immediately after the raid, but shortly thereafter, my son and I decided that, one, he would continue the practice. Two, I would begin to retire away from the practice, but of course, we couldn't dump patients. So we had to make that transition. Yes, we made that decision then. It was a very painful experience to be raided by the DEA. There were over 20 agents there. They tore my condo where my wife was apart. They then went in the office and spent over 10 hours, I think, going through the office, posting signs. And my office is one of 3 doctors in that building, posting signs that patients could not get in. It was an extremely painful experience. Subsequently, they didn't find anything. So there's been nothing done about that. But, it was still painful.
Well, you, at that point, obviously were under investigation by DEA. Did they interview you in regard to that
Yes, they
investigation?
did. Yes, they did.
Why do you think you were being investigated?
Oh, well, they told me that. There had been a conversation when TL, I'm probably going to slip up and use his first name, when TL was in the Harrison County correction facility, that he had called me and talked to me, and they misunderstood something I said, which they later did acknowledge they misunderstood, and thought that I was writing him prescriptions without any kind of documentation, which was not true. They also stated, but never have provided us, nor could y'all provide anything, that there were confidential informants. We know nothing about any confidential informant.
So are you concluding the DEA has not done anything with it because there's no basis?
Yes, that's exactly what we
But
think.
you don't know what DEA is doing with this information now, do you?
We've talked a bit with their,
Well, I have to object because we're getting into speculation about U.S. federal matter, and it's we're getting far afield from what we're here for. And if I would object to the irrelevance and the unfair prejudicial nature, also you requiring him to talk about matters that would be hearsay and speculate.
He opened that door when he said DEA hasn't done anything because they don't have any basis. He made that statement moments ago. I just want to confirm the fact that he has no idea whether or not DEA is going to be moving forward with anything.
Then to that extent, I would not object, but I would submit that should be the end of that and then request to move ahead of that. If he wants, we accept Mr. Ingram's statement. If that's a proper, that he doesn't know what's in the minds of the U.S. Attorney, that's fine, or the DEA.
Well, then that's fine, but as long as you recognize the fact, you don't think they have a basis, but DEA may disagree with that. Would you agree with that?
I'm gonna sustain the objection. Thank you.
Now,
I
you,
don't know, does that mean I don't answer?
Correct.
now, you told DEA I retired from the active practice. Where?
Huh?
You
My
don't say,
practice was in Gulfport and Biloxi.
okay. But you don't state where. Are you, at that point, were you licensed anywhere else?
I'm licensed in Florida, Alabama, and Georgia.
Okay, so you don't state, if you're telling DEA I retire from the active practice, you don't state whether or not you're retiring in Alabama or Florida in addition to Mississippi.
You do understand how the DEA numbers work, right?
I do understand, but that's not what you're saying, so.
But that DEA was specific to that office. And when I closed that office, that DEA was no longer needed because it was specific to that office. At that time, I did have a forwarded DEA. Later, I also closed it.
Now, prior to this family charging you, Doctor, the board attempted to and chatted and negotiated with you as far as possible retirement of your practice in Mississippi.
I'm not sure what you're asking.
But I would object if we're gonna talk about negotiations and settlements. That would not, any potential discussion for a compromise settlement, that's not admissible.
The investigative staff of the board gave Dr. Jackson an opportunity to retire, and this, we wouldn't be here today if that happened. I agree with you. That was a settlement form, but he denied that. I just want that into the record. He declined to retire from the active practice.
That was not what was offered.
Well,
Wanted me to.
I'm sorry, Doctor, wait, I'm sorry, Doctor, whenever the objection is being made, the witness has to wait until the judge rules upon that objection, and I'm not getting on to anybody, and I hope I'm not speaking out of turn.
I'll withdraw the question.
Thank you.
You do know that any action by this board, whether voluntary or as a result of this hearing, is reported to National Practitioner Data Bank. Is that correct?
Absolutely. That's why I am here.
And you didn't want that to happen, did you?
No, I know I'm going to be reported to the national database. I did not want to voluntarily surrender my license. And that was what I was offered.
Because that would be reported to the data bank.
No, that's much more severe than that. If y'all take my license, or if I voluntarily suspend it, that will also make it where I cannot do anything anywhere. In fact, since I've been through, I've tried to do locum tenens, and I have been unsuccessful in doing it because of this outstanding investigation. So that's why I'm here, because I do want to continue to do some locum tenens. I have a VA opportunity to do basic TBI exams, traumatic brain injury exams, which I can't do as long as I'm suspended or whatever the other term is, terminated in this state. So I'm here.
10 days after DEA executed the search warrant of your clinic, you applied for a license in Alabama. Is that correct?
I did, yes. I already knew I was moving here.
At that point, you obviously were under investigation by DEA. Just acknowledge that.
Yeah.
Were you honest with them?
Sure.
I want you to read question number 9 on your application for a license in Alabama.
Okay,
No, read the question, please.
sorry. The question is, are you subject to an investigation or a formal complaint against your license been filed by an investigating board, state, federal, regulatory, or law enforcement? My response was no. I did contact the lady and told her that there was this investigation going in Mississippi, and I didn't know how to answer that question.
It's just to the record, what's the next thing?
11.
Do you need that back? Okay.
I'm just looking at it. I'd like to introduce this as board exhibit number 11.
And it was not a new application for that license. That was just reactivating.
No objection.
All right, Doc, you're under oath. Who at the Alabama board did you call and say, oh, by the way, I'm under investigation, after you answered no to this question?
I called them. I do not know. I didn't write it down. I didn't keep the thing. It occurred to me, actually, I talked to Mike, and Mike said, you probably didn't answer that question correctly, so I called and said, I do have some type of investigation going on for the board. in Mississippi. And she said she didn't think that was an issue, whether they noted it or not noted it, I don't know. The way I read that, I didn't think this applied, but then I'm not an attorney and all this stuff is kind of confusing to me.
So when did you call Alabama and spoke with that lady?
It was at the time that that application was filed, and shortly thereafter, when I talked to Mike about what I had put, I decided I needed to be sure they knew there was something ongoing.
So May
It
or
would have
June?
been the same week of which that application went in.
So, okay, you made the application on May 20, 2020, it would have been in May.
It would have been in May, yes. I was at that point closing the office and getting ready to move to the retirement community.
All right, now you've acknowledged that you had a professional sexual relationship with patient TL.
I don't think it was a professional sexual relationship. I had a sexual relationship for sure.
My error in describing. You're acknowledging the fact that you committed professional sexual misconduct.
I did, yes.
How old are you, doctor?
I am 70.
How old is patient TL?
I think he's 29 now,
He was 27 back then.
28, I think.
You also acknowledge that you entered into a business relationship with the patient known as JT Construction, which is an acronym standing for your first name, Joseph, and the patient's last name. Is that correct?
No, it's his first name and my first name, Joe, and T, which you don't want me to say that.
That's fine. That company's name was later changed to Rock Solid Solutions.
I know nothing about that.
Okay.
I terminated that for business relationship about 5 months before he was sent into prison.
This sexual relationship occurred at the time you were also treating the patient.
It began long before I started treating him, but yes.
Okay. Well, how long have you had this sexual relationship with patient TL?
It started in July of, I don't have those dates,
Just a part.
July of 2017. And it continued until July of 2019.
Okay, so if the sexual relationship began in July 2019, 17, excuse me, he came to your office in August of 2017 seeking.
Oh, yes. I can clarify that before you try to put all that up, because you keep saying it. We've told you already multiple times that isn't how it works. He filled out a patient information form in August. That is just beginning the process. At that point, Ms. Betty goes through the information, it gets entered into the computer. He did not actually come for appointment or get seen officially until October the 10th, 2017. So the patient information that is on that October 10th, 2017 note dates back to August, but it was not applicable at that time. The dictation above reveals that to be the case.
I'll give you a benefit of the doubt. Then the sexual relationship pre-existed, and within a month after the sexual relationship, you started treating this patient in October. Within that period of time, you started treating the patient in October. Is that correct?
Correct.
You admit that you provide this patient with your email address, phone number, and a photo of your Florida driver's license.
I did. We were in a business. He was doing the application for the legal, whatever you call it, LLC or PLLC or something. He also negotiated 2 loans. He lived with me for 4 months. So yeah, he had all that available. He used my credit card recurrently to charge for building supplies because we often would not get an upfront deposit enough to cover those business supplies. So he charged it to me and supposedly would repay me.
Do you acknowledge that the text between you and patient TL were, many of them were of a sexual contact, sexual nature?
Almost all of them were, yes.
I'm sorry, Mr. Ingram, can I look at number 11 while you were talking to us? You needed it in front of the last exhibit you had bid up, big number 11.
Yes. Well, I'll provide that to you. I'll hold off. I'll use these in just a few minutes. Doctor, would you agree that patient TL also had issues with the law?
Yes, I would agree with that.
You mentioned earlier that at one point he was put incarcerated.
He was arrested one time for domestic abuse, that I bonded him out. That was like in September or something, I think, of 2018. Off the top of my head, those dates may not be correct. So yes, I knew about that. I knew he had been in prison prior to me meeting him as well.
Did you take that into consideration when you treated this patient?
I did.
Would you agree with me that one of the principal reasons why a physician should not have a romantic or sexual relationship with a patient, other than the harm that that could cause the patient, is also that the relationship could destroy the physician's objectivity when treating the patient?
I would not disagree with that, certainly.
Let me present you the patient record. This is the board exhibit number 6.
What do you want to drive me to?
I'm sorry, I'll get to that in just a second. We'll let you have that.
These are my copies, which are easier for me to read.
Well, now that you say that, you can use that, but I should have the opportunity to take a look at what you're testifying to.
These are done by date, and they split out, so you don't get a continuous reprint. I find the electronic records hard to read.
I do too. So basically, what you have in front of you is a medical record for patient TL, is that correct?
Yes, everything that was in the electronic records. As you know, the actual chart was taken when the DEA came in, and we don't know what happened to that chart.
Are you saying that that may be different from what DEA seized?
No, I'm saying there was a paper chart that might have other information like lab testing, the dates. I thought it would have MPM until you showed me that it didn't. But we don't know what happened to that paper chart. We don't know what was in that paper chart. As you know, we asked y'all to obtain it. We can get that.
Are you saying that DEA seized paper chart and did not provide you a copy?
Absolutely, they did not. My business managers here will solidify that they took not only that chart, but 5 other charts.
We're only talking about patient TL for the time being. So are you saying that DEA, and take a look at that exhibit. That's what DEA provided. Just take a look at that exhibit.
What do you want me to look at?
Just thumb through it to make sure that that's the patient record.
Okay, the first like 5 or 6 pages is what the computer prints, it's not really part of the record. The record starts on, well, this is not correct either. The first, oh, this is going backwards, okay. So it starts with the last visit, which is July the 17th, 2019, and then it works all of its way, or it should work all of its way to the initial visit that was on October 10th. Like I said, these are difficult to handle when they come out of the computer. Yeah, October the 10th, 2017. So it has all those in a free-flowing type way rather than to split them out.
Sure.
Visit by visit.
Okay, that blue divider, after that blue divider, which I put in now, I should say. And what do you see?
Lab history, blank sheet. I don't know where that came from. The next blue sheet is determination letter.
That's
Him.
Okay, keep turning.
There is handwritten, this is his initial handwritten thing when he came in on August the 14th, 2017, that he filled out that got transcribed over into the chart. That also included, of course, a review of systems. These are our policy records about not showing. This is a blank examination sheet, which is how the computer prints out the exam before any information is put in it. So I don't know what that sheet is in there for, but that's the last thing.
So you would acknowledge that there are, in there is the paper documents when he initially made his application, so to speak, filled out,
Right.
seeking medical care.
I didn't
And policy.
deny that it was there because we obviously had it to enter it into the record. I'm not sure what you're asking me.
That's paper copy. That's not an electronic medical record.
Correct. It's the paper copy.
No moment ago, I understood you to say that there's additional paper.
I do not.
DEA did not, other than this?
There is, in most of our charts, other signed information about releases of information, stuff like that. There are sometimes blood pressures, pulses, stuff like that that are entered in that I don't move over into the electronic record, so it's never done. If there was loose leaf lab, it would be in there. It should have been included in a note, but I didn't always do that. But yeah, that's the paper that he filled out. What else was in that chart, I don't know, because I never got to see it again. You know, I was surprised when you found that the PMPs were not done, because I was sure they would be in the paper chart. And I didn't know that until you met with me.
We're going to get to this in a few minutes. You now understand that when you query the PMP, they have a record.
I never queried the PMP up till the time that we were capable of doing that electronically. Prior to that, my office did it, and I never looked.
You understand it doesn't make any difference.
I
The query,
understand.
that you can have a designee, and if that designee on your behalf queries, there's a record of it.
I know that now, yes.
You're not denying that you issued these prescriptions, is that correct?
I'm not denying if they've got my signature on them. They all appear to have my signature on them. I don't know what this is.
You have a few call-ins. Let's get that out of the way.
There is one in here that is not mine. It was written, I know, because he was in the emergency room for Merit Health. It was written on June the 3rd, 2019, and it was for 10 Ultram after he had got hit in the head. That is not mine. There is a Valium prescription dated 8/25/18 that's Ultram prescription for 18 that was a called-in prescription under my name.
You're not, I mean, it was, are you aware of that prescription called in?
I was not aware of it until y'all brought all this stuff in front of me, but I don't deny that I called it in. I just didn't remember. There is a 8/30/18 prescription for Klonopin, 2 of them, also called in. It looks like Celexa and Klonopin was called in at that time. There is a prescription on September the 30th, no date as to what year, maybe 18, where 5 Subutex were called in. I do remember that prescription. There is the February the 6th, 2019 testosterone prescription that I do remember calling in. And that is all the ones that are actually signed prescriptions.
Turn to page 158 of your medical records.
Did I find that?
At the very bottom of the page on the right margin, it states,
Oh, my page is okay. Got it. Got it.
that was the initial visit, correct? October 10, 2017?
Yes, sir.
What was his very first complaint to you on that day?
Okay. By that time, he had come off of the opiates and was using Kratom, but not any other opiate. He came into the office because he was having a chronic dysaesthetic burning pain in his arm, and he wanted to get medicine to try to treat that for pain because we knew and had discussed about his opiate risk and addiction. We decided that his best choice at that time was to go with Suboxone.
All right, so I want to make sure you answer my question. Out of the starting block, it says, briefly state what the recent symptoms are that bring you here today. He stated addiction to opioids and cannot stop.
And this is where you continue to get confused.
I'm asking you to say what's in the record, doctor. What's in the record?
I'm trying to tell you. In August, when this information was put in, that's what his complaint was. It was not the complaint when he showed up on October the 10th. We tried to tell you that multiple times.
I'm asking the questions, okay? It says, very briefly state what the reasons, symptoms are that bring you here today, and what did he put down?
He put addiction to opiates and cannot stop.
It cannot stop, okay? On the history of present illness, HPI, won't you read that for the benefit of the board?
This 26-year-old presents having previously been on a Suboxone program, gradually tapered, and had done well. Most recently, he has not been using opiates on any frequent basis, but is concerned because he is having burning dysesthesia and pain in the area of his left forearm, where he earlier had an injury, and has been left with a continuing discomfort and pain. Because of this concern about the use of opiates and his past possible abuse, he is asking to move into the buprenorphine program, but at this point, primarily for pain, since he is not actively using opiates. And that was true as of October the 10th, 2017, to the best of my knowledge.
past history, you agree with me, it states currently not on opioids, but having pain and fears resuming opioids, current opioids, narcotic drug of choice, and he puts what?
Oxycodone,
The average daily dosage he states that he's taking is what?
90 milligrams.
Last time you used an opioid was when?
He filled this out in August. He had not used an opiate for a couple of weeks at the time I saw him.
Even though this is dated October 10, 2017, he says it was filled out in August.
How many times do I have to explain?
Doctor, I'm just, because the records are not, do not appear to be accurate. Now answer the question.
Okay, you got it wherever you had it, right here, and you got it clear cut. This is what he filled out on August the 14th, 2017. That's where all the information other than my dictated stuff came from. There was a change from when he filled this out in August and when I saw him in October. But the electronic chart has already been filled out. So the electronic chart is reflecting what he said back in August, not what he was telling me in October.
So I can't rely on this date when it says October 10, 2017.
You can rely that that was the day he was seen. Any of the patient information data dates back to August.
How long have you been using electronic medical records?
Whenever they were mandated by Congress, I don't remember. They've been a pain.
You asked the question, what other medications or illicit substances have you used in the past? Include alcohol, stimulants, benzodiazepines, anxiety, medication, cocaine, marijuana, cocaine again, inhalants, hallucinogens, PCP, sedatives, and what did he say?
All.
You asked the question, if any use of the above, at what age did you use, and did you use any for a regular period of time? And what did he say?
Too much to recall.
You asked the question, what changes in your use of substances has occurred over time?
Increased.
What substances have you used in the last several weeks?
Opioids.
When was the last use of any of these substances, and what did he say?
Today, this is of course the August patient information, not the date of this appointment.
So the board members, when they go back in executive sessions, you have to say all this information relates back to much earlier.
You have it there so they can actually read what you filled out. And this was copied over here. So I'm not saying anything that you don't have in your records.
You asked the question, what are you seeking help at this time? And are you doing so voluntarily or coerced by others? Did he answer the question?
It looks to be blank.
What consequences do you see if you do not enter into treatment?
I will never be independent of opiates.
You asked the question, have you tried abstinence or treatment programs in the past? And what did he say? Oh, you should, if so, for how long?
Months is all he said.
I don't see any clarification. Did you ask him to clarify that?
I don't usually go through and clarify what's already been put in. It's all in my dictation for what I'm doing on that day. And that's that top paragraph that ends with that past history comment.
Okay. Page 159. You asked the question, have you engaged in any, number 8, have you engaged in any illegal activities in order to obtain drugs? What did he say?
Where?
Question number 8 on the next page.
He said yes. Oh, that's what Charles said. Oh, he said yes.
So you got a patient acknowledging he's probably committed some act of criminal conduct, which you've already acknowledged that. I'm just saying.
Objection. He's making, it's inappropriate for counsel to make comments without allowing the witness to make a response to that comment.
This is cross-examination. I can lead.
Yes, sir.
I'm
But you
asking
got,
him.
I don't want to talk to opposing counsel. Now, I'm being inappropriate if I speak to counsel opposite. But counsel opposite, after the witness gave an answer to a question, counsel opposite made some commentaries on his opinion on the observations. And then he started asking, moving on to a different question. So I would ask for the witness to be allowed to answer or respond to the comments or observations made. And I would also ask the counsel not to make observations unless it's in the form of a question.
I'm going to overrule your objection based on the fact that the witness is adverse and he's also been making comments as well. So I'm trying to give him a little leeway since he is crossed.
I think he's already stated that patient TL's had a criminal record. Now, page 160. Patient TL states he's had no hospitalization or surgeries. Is that correct?
Correct.
Page 160. We admit that patient TL stated that he has had prior treatment for drugs and or alcohol.
I'm sorry, where are you seeing that?
You look down under past history, patient reports the following reasons for hospitalization not including surgeries, he put none.
Right.
He also says, patient reports the following treatments with dates for emotional disorders, alcohol, and drug abuse. What did he say?
He said yes, with no clarification.
Did you inquire?
I don't remember.
Take your time. Show me any entry in the record where you reached out to obtain records from a previous treatment facility.
We did not because there were none that we could identify.
Yet he answered the question, yes. I'm confused. So,
Unless he had done them when he was in prison, I don't know when he did it.
doctor, look on page, the very first visit. Oh, by the way, let me mention, I'm sorry, go back to that, you state August application.
That you filled out?
Yes. Real quick, when did you first know patient Tio?
July.
July what?
I don't know the day, but it was July.
2017?
Yeah.
And you say that within several months after that, or in August, it's when you filled out this application?
It was probably a couple of weeks after I originally met him and found out that, you know, he had been in prison, that he had had some issues with opiates. And I said, well, you may need to consider doing an addiction program.
All right. You filled this thing out in August. What year in August does your record reflect this occurred?
Say it again.
What's the year in August?
2017.
I'm talking about the date of the application.
August 14th, 2017.
Turn the page over. What does it say? History of present illness, August 8, 2012. I'm confused.
Me too. Okay, the first is his information that he fills out about where he works, what his insurance is, and all of that. The date written at the top of that is 8/14/17. The next page is a entry that he filled out, at the top of which says August the 8th, 2012.
Yeah.
That is something the computer put there. I have no idea why or where, but it may have been when we actually filled out and made these forms originally to give to people. Ms. Benny may know that, I don't.
Turn to page 161. This is the first. last entry for your very first visit of October 10, 2017. Is that correct?
No, that's the last of the history.
Yeah, that's what I'm saying. So you did a physical examination. One of the vitals, you noted the vitals there. Is that correct?
The vital signs are there, yes, correct.
Okay. Would you agree with me that nowhere else in that record are there vitals recorded?
Not that I know of, no.
Are you saying you did not take a vital?
I never did. That was something done when they went through with the secretary at the front. She would do blood pressures and pulses when we felt it appropriate.
So you let them make that decision. But there's nothing in the record, is that correct?
I have not found any other blood pressures when I went through those records other than this one.
Page 158, again, we're at the very first visit. Board members may be better individuals ask this question, but show me any diagnostic or radiological test, if performed, which substantiates your diagnosis of dysesthesia, pain in the area of the left forearm.
There is no diagnostic test that would show that.
Have you run during the entire 2-year period? He complained of pain on multiple occasions. Have you sent him to? You sought any help from any consultants or experts in any other field?
And you do realize I'm a neurologist and a psychiatrist. Who would I have referred him to?
Let's start off with testosterone. Would you not refer him to a urologist?
Should I have? Yes, probably. Did I? One of the chronic problems with long-term opiate treatment, particularly with Suboxone, is testosterone deficiency. So I should have had a lab. I think I did. Maybe I didn't. But my pattern was if the patients were complaining of symptoms to that, to do the lab, prove it, and then to treat them with testosterone. Most of these people are poor and they can't afford to see or get multiple testing. And that certainly was true with Tom.
We would admit that probably a referral to a urologist probably would be the better choice.
It would be a better choice, yes.
Very last entry, very last visit, July 17, 2019. Page 4.
Okay.
Shows encounter. Very briefly state what reasons that you're bringing here today. Again, he states after 2 years, he states addiction to opioids and cannot stop. Is that correct?
This is the electronic medical record. It repeats whatever is put in from the very first visit. It does not change it. We did not change it.
So basically what you're saying, this electronic medical record is making a statement which may not be accurate if you ask the patient.
That would be absolutely correct.
Last date of last opioid agreement, August 12, 2018. Show me anywhere in the record where you have an opioid agreement.
That would have been in that paper chart because it is not scanned in. As you can ask my office manager, it would not have been scanned into the chart.
You don't have any idea where it is.
I have an idea where it is.
I'm
It's
asking
with
you
the
the question.
DEA,
All right.
wherever that chart is. Is that all you want out of that record?
Yes. Now, you heard me state that effective October 28, 2018, the board amended rules 2640, rule 1.14 to require that any licensee operating a pain management clinic must query the PMP at every visit wherein a controlled substance is prescribed. You understand that?
I did, yes, sir.
You understand that, what's the purpose for querying the data bank? Can you tell me?
The ideal initially was to cut down on doctor shopping, where people would go and see multiple physicians and get multiple prescriptions. I assume that's still the principal purpose for it.
You would admit, that during the period of time in which you treated this patient, October 2017 to July 2019, almost 2 years, you queried PMP only 3 times.
I did not know that until you told me, because that appears to be the case.
Almost invariably, every interest. Turn to page 148, if you would,
Are we back in that record?
please.
There.
All right. On that page, you'll see at the very bottom, MP has been reviewed with the patient and is included with the chart. Would it surprise you if you had that statement in virtually every entry on this record?
No, it would not, because I thought they were being done every time.
But they're not in the record, are they?
They weren't done.
Is that because it's electronic medical record and it just regurgitates or repeats these every visit?
Yes, it does.
That's a pretty big defect in electronic medical record. Would you not agree? Because it's making a statement that's not accurate.
I would agree.
All right, you got the prescription in front of you?
Yes, sir.
Turn to the May 28, 2018 prescription. That's 30, you agree with me, this was prescription dated
I
May
haven't
28?
found it yet.
Oh, I'm sorry.
All right, I found it.
I'm sorry about that. It's dated May 28, 2018, is that correct?
It is.
30 Percocet.
It is.
And if you look on page 130 of your patient record, that's your entry for that particular date, is that correct?
Please give me time to find it. This is not easy to locate. The May 29th record is on page 130.
And you state under HPI, what is the purpose for your return visit and what did the patient state?
Well, that's me stating a patient contacted me 2 days after he got the Percocet. He had gone through 2/3 of them. He has had this problem in the past of using opiates and now is afraid he is falling back into that trap. He is still having daily pain from the nerve injury. This is after his head injury. That now is aggravated by his back, and he works in construction. He is requesting to return to Subutex.
So the day after the May 28, 2018 prescription for 30 Percocet, he's back in your office stating that he took 2/3 of the drug, of the Percocet, correct?
That is correct.
And he is requesting return to buprenorphine.
Correct.
And so at the end of that entry, page 135, that May 29 entry, you said prescribe buprenorphine and remove Percocet and Klonopin. Is that correct? That's on page 135.
I'm there finally. Yes, it says prescribe buprenorphine in what he got, to stop the Percocet. So there must have been some, that were still out at the emergency room and at the, pharmacy. And then, it says to stop the Klonopin.
You make that statement because you have told this patient from the very beginning, I don't prescribe Buprenex at the same time I'm prescribing an opioid. I don't
That's
combine the two.
absolutely true, yes.
Several days later, on June 3, 2018, on 5 days after you told him, stop taking the opioids, I'm gonna you need to go back to Suboxone. You went out there and obtained a prescription from Dr. Walchak, is that correct?
Where are you? I don't know.
What's on the prescription?
We're on the prescription now.
I'll go. Go 2 pages over on the prescription profile, you'll see. Just 5 days later. What did the patient do?
That is not mine. That's the ER visit. If that's 5 days later, then he must have gone back, after the initial head injury, and had seen them in the ER.
So patient went to the ER on June 3. Well, it doesn't state that, but you're saying that prescription came out of an emergency room?
It's not mine. It's from Merit Health.
Well, that's what it says. I mean, I'm telling you, does it say emergency room on there?
No, but he was never treated in the hospital, so it had to have been from the
Well,
emergency room.
he could have gone just to Dr. Walchak's office, couldn't he? You got it.
I guess so. I know he didn't, but
So you took the patient off of opioids, put him on Suboxone. Within a matter of days, he's getting a prescription for Ultram from Dr. Walchak. And then he comes, what's the next office visit after that?
June the 24th, 2018.
What did you prescribe him then? Or tell me what that return visit was for.
Okay. This is when I
Page
documented,
125.
correct. This is when I documented that he was mugged and received a 4-inch occipital laceration, and a gunshot wound, which he had had previously, to the calf. He was having increasing back pain, but doing well on stimulants and testosterone. He's working 12-hour days. And that's pretty much all that's in the new information.
Did you run a PMP on that day, June 24th?
You know, I didn't.
You would have discovered at the time that he went to Dr. Walchak and got that prescription for Ultram.
I already knew he had been to the emergency room. The guy lived with me.
Is there any record? Show me where you note that in the record here.
I didn't note it.
Stay on page on June 24th. But flip on the prescriptions that you have, flip over one more and you'll see What's the next entry in the record? Do you have?
There is the recopying of the Suboxone program note, which had been from an earlier visit, not this visit. There is recopying of the review of systems. There's recopying of the physical exam.
Okay, on that, you're on June 24, correct?
I am, yes.
And on that date, you issued him a prescription. Those in the record, or you can,
I gave him another Suboxone prescription.
am I correct to say 60 Suboxone?
That is correct.
Which would be a 60-day supply, correct?
No, that would be a 30-day supply, 2 a day.
But there was one refill. So that would be a 30-day.
I'm sorry, yes, sir. Yes.
Okay, it's not uncommon, since you're living with this guy, or he was living with you from time to time, he would fill his prescriptions partial filling, 5 here, 10 here. In other words, he wouldn't get the entire amount. Is that because of lack of money or what?
Yeah.
Is he paying cash?
I have no idea how he paid, but I imagine so. He didn't have a credit card. And I didn't pay for it.
So you weren't charging him for your medical care either?
No.
So that, on that date, June 24, you issued him prescription for 8 milligram buprenorphine, enough for a 60-day supply. And what was the next visit after that? I'll take that back. Turn to July 31, 2018. It would be page 110.
Okay.
That would be 1 month later after you issued the prescription for 60 Suboxone. What did the patient tell you?
Okay. He had come back and he had reduced himself. He actually did this on a couple occasions, down to no more than 1/4 of a tablet of Suboxone. And he wanted to see what he could do to try to come off all the way. On 2 separate occasions, he had come down to that low of a dose, and we made a transition to Ultram to try to wean him all the way off. And he was successful on at least 2 occasions.
You would agree with me on that date, July 31, you make a statement here, wants to move to less strong medication as the Subutex at 1/4 tab is too strong. Correct?
Yes, sir. I see what you're reading. Yes, sir.
On page 115, in the tail end of that particular entry, you state, that's page 115, Doc.
I have it.
Okay. You state prescribed tramadol and Neurontin, removed buprenorphine 8 milligrams sublingual tablet, 1/2 to 1 tab. Is that correct?
Correct.
And so basically what you're doing is you're telling him, don't take it?
Right. He had not gotten the full amounts out of the pharmacy, so we canceled what was outstanding, and we gave him the Ultram on a tapering dose, which unfortunately is not in here, but he received to try to get him off more smoothly. I don't know if this is the appropriate time to say it, but Suboxone, 1 milligram of Suboxone is like 30 milligrams of morphine. So when you get down to a really low dose of Suboxone, you're still on a really high dose, as far as I'm concerned, of morphine, and it's very hard to make that transition over.
So you're basically saying, stop taking the buprenorphine, correct?
Correct.
And you prescribed tramadol to him because you don't want, you tell your patient, don't mix opioids with the buprenorphine.
Correct.
Once you look at the PMP. that June 24th prescription. Would you turn in the June 24th prescription? Here, I'm sorry.
What here? Here it is, you already marked it.
Find it. What's the prescription number on the back of the page? Flip
No, I know that.
it over and look at the pharmacy. What's the prescription number on that?
Is that the thing at the top? 4016136.
Okay. So you admitted, you acknowledged a few minutes ago that TL oftentimes would fill prescriptions partially.
Piecemeal, yes.
Look at right here, this is that prescription number you're talking about.
Okay.
You would agree that he picked up 10, June 25, 10 on July 5, 10 on July 9, 5 on July 20, 5 on July 27. Prescription number, 5 on August 2 and 10 on August 9.
I'm sorry, I'm not reading the right spot. You're correct.
So he still kept taking that buprenorphine on August, excuse me, yeah, that's right, August 2 and August 9.
Yeah, yes, sir.
After you prescribed to him the Tramadol. So you tell him, stop taking the buprenorphine, and yet he's continuing to fill it while taking the Ultram.
It appears so. It doesn't appear that the last prescription was on August the 9th, that he got 10, and he got the prescription for the Ultram on August the 6th. So for 3 days, he had either used 10 or destroyed them. I don't know what he did.
You would acknowledge to me, if you had checked the PMP, you would have uncovered that, probably have confronted him with it.
I would have, yes, sir.
I mentioned this before, let's talk about the Adderall. How many prescriptions do you think you wrote to him for Adderall?
I do not know.
Would 7 seem to be during the profile period? February 19, 2018, March 22, 2018, May 22, 2018, July 25, 2018, August 14, 2018, October 9, 2018, and July 10, 2019.
That sounds correct, yes.
Look on page 148 of your medical record.
Yes, sir.
That corresponds to the first time you issued him a prescription, where you talk about the ADHD. Read that HPI. Since starting Suboxone.
Want me to read it?
Please.
Since restarting Suboxone for pain, he is having more problems with the ADHD he suffered from as an adolescent and would like to restart.
All right. You would testify and state to this board that there are diagnostic tests that physicians use before you render a diagnosis of ADHD. Is that correct?
Absolutely, they are not.
So there's no diagnostic test, there's no questionnaire or anything that the doctor can use to render a diagnosis of ADHD?
There's a questionnaire, there's no diagnostic testing.
Okay, show me that questionnaire in your record.
I didn't put a questionnaire in this record, why would I?
Okay, you tell me, why didn't you?
I'm a psychiatrist, I don't have to ask those questions. I get that out of the present illness, and I get that out of the mental status.
Show me the mental status.
Patient is, this is on page 151. The patient is alert, oriented ×3 with intact recent remote and recall memory. This affect is appropriate to euphonic to slightly depressed mood without evidence of homicidal or suicidal ideation and no evidence of psychotic thought disorder. He has moderate difficulty with focusing and inattention. Cranial nerves, 2 through 12 are intact, the rest is just a neurological exam.
Is that same thing repeated in almost every visit?
It would be after that, yes.
That's your justification for using Adderall?
Yeah.
On August 14, 2018,
Page,
I'm sorry. In terms of the prescription, if you will, to August 14, 2018.
you're talking here now, right? Not the records.
Prescription. And I'm going to get you turned to the record as well.
No, that's his birthday. The 24th, August the 24th.
August 14.
Okay, got it.
Okay. Now turn to page, simultaneously, if you would, keep that prescription open and turn to page 105 of your medical record.
Yes, sir.
You've got two entries on that on August 14. Can you explain why? You got one at 8:54 a.m. and then same date at 12 o'clock approximately, which would be page 100, 1214 to be exact. Now, why would you have two entries on the same day?
I can tell you why I have two entries. If the medical record, the electronic medical record allows no change or correction. So if there is something that I have found out after I have closed the record, I have to reopen and then re-enter a new record. It is possible to put an addendum in, but that's not the way I usually did it. I would reopen the record and put in the information that I had not put in the first time.
Yeah.
There are many problems with that record, and that's just one of them.
On that prescription for 70, you state one tab, this is the Adderall 20 milligram, one tab PO BID may occasionally use TID, okay for early refill. Is that correct?
Yes, sir.
You understand that prescription was written 10 to 11 days early from a previous Adderall prescription. Can you explain why?
Yes, sir. I think you have text back and forth between he and I on that too. Basically, he had asked me for a refill and it was early, and I said I could not refill it, and that, you know, he had taken more than he should have, and he explained, and I knew, because again, we worked together in the construction business, that he had been taking 3 a day instead of the 2 a day I had recommended. So he had run out earlier than he should have. So I agreed that I would go ahead and write that prescription early. Only time I write a prescription early.
Got in front of you a copy of the text. On August 14, that same date that you issued that prescription for 70 Adderall, correct?
I can't see a date on this, but yes, I have it. Okay, thank you, sir.
Is that your number, area code 850-501-0066?
Yes, it is. Or was then, not now.
He's saying, need card info again, though. What was that about?
He needed my credit card information to charge some stuff that, I'm blanking on the name of the place, I guess I'm a bit nervous. Home Depot.
And you gave him your credit card number?
I think at that point, I didn't give him a credit card, I think I gave him my debit card.
That's your debit card number.
Excuse me, is there an
I
objection?
would, yes, ma'am, I was gonna ask, I didn't want to interrupt the flow of what they were saying, but I would ask for the witness to be allowed to look at the text if
He's got it.
okay, I'm sorry, he has a copy of the same thing you're looking at, okay, I beg your pardon.
And after you gave him your debit card number, what did he say?
Oh, and Adderall.
And what was your response?
I forgot, I will do it now. You will need an appointment in a month to rewrite everything. We will have to do a UDS drug screen and pill count. Cost is $130. I will pay if you need it, but need a real visit.
What do you mean by real visit?
Meant that he could not just call me and ask me for a prescription. He had to come into the office to get the medication.
Okay, so contrary, so against your best judgment, you went ahead and filled that prescription, issued that prescription on August 14, which is 10 to 11 days earlier from a previous prescription, is that
Right.
correct?
As you know, underneath that, I said the Adderall was written on July the 25th. I can't write another until August the 21st. The state is watching for early refills of medication. We'll bring RX, and then we don't have any more of that text comment. But that's basically when he and I discussed the fact he was doing it early. And he said the reason was he had taken more medicine than he should because of the amount of work he was doing.
2 weeks prior to that, when he texted you like that and said, I want some more Adderall, which would be 10, 11 days early, you counseled him about Adderall. Turn to page 110 of your medical record. This is July 31. At the very tail end of July 31 on page 115. You stated prescribe Adderall 20 milligram oral tab, 1 tab pill, BID number 60, 0 refill. And what did you tell the patient at that point?
Warned to decrease Adderall and about the seizure risk with both Adderall and Ultram.
So that was only 2 weeks prior to you issuing that prescription for Adderall 10 days early. Is that correct?
I don't have all these dates, but if you say so, I guess that's true.
July 31 and August 14, would that be about 2 weeks?
Yes, sir.
So you admit that you probably ill-advised issued a prescription 10 to 11 days early, increased the dosage to 3 times a day, despite the warning that he needs to cut back. Would you agree with that?
Yes, I would agree with that.
You heard my comment earlier about romantic relationships and objectivity. Were you being objective when you made that decision?
Probably not, sir.
Excuse me, Mr. Ingram, sorry for the interruption. I think, a couple of the board members would like to take a break, maybe a 5 or 10 minute break. I do understand.
What time is
your
lunch? It's 11:30.
It's 11:28, so,
You want to go ahead and take a lunch break?
Lunch is scheduled to be here any minute.
yes.
I'm sorry.
Lunch is scheduled to be here at 11:30, so we can go ahead and break for lunch if that, or
That's
how,
fine. That's fine.
I didn't know how much longer you had on
I
this.
don't have too much longer, but let's don't hold up much.
We'll recess for 12:30. We'll recess till 12:30 for lunch.
What do I do with all?
I should have gone in a friendship.
I had 11.
I haven't had a
11.
career.
That's right, go into that.
Were y'all looking for it?
No.
I was just saying I had 11. If you needed to describe where we're looking at it.
Okay. Lifetime. You don't have a lot of years to make it back.
Go back over there now, or wait.
Go ahead, fixture. She's one that helps us with our newsletter, Facebook, Instagram.
It's really fun.
Yeah.
You can lock that chair.
I'll just remember not to look at that.
They had a fixture.
I think it's one on the website. You want it to?
Yeah, so we'll go back to that. Thank you.
He's still writing.
And you went to law school. You did too. He went to Ole Miss High School. He played for them. And he said that. He said, if I stay up here
Left side's blocked. Push it down.
Oh, okay.
We both learned.
Hello?
Every day's a school day, right?
Right.
Board's now back in session. Please resume previous business.
May I proceed? I'll be very brief.
Just part of the same.
That's fine. Dr. Jackson's already testified about the text where the patient said, oh, the Adderall. I'm going to go ahead and place that for the record for exhibit number 12.
We cannot hear, Sarah.
You hard of hearing like me? Because there has already been testimony concerning the text between Dr. Jackson and patient TL, where they talked about, oh, Adderall. I'm going to go ahead and put that one text into the record. The board exhibit number 12, I do believe. Any objection?
And no objection.
I am not sure this is,
Let me wrap things up, Doc. Okay, page 15 of the affidavit you may or may not recall, we listed 6 prescriptions that you issued to the patient. I think your previous testimony indicated that all but May 22 were call-in prescriptions. And these prescriptions are not in the record. You do acknowledge that the rules and regulations do state that when you issue a prescription, you must note it in the record. Is that correct?
I am aware of that. Unfortunately, I didn't do it.
Thank you. I tender the witness.
I had some candy in my mouth. I had to get rid of that kind of quickly. Doctor, I'm just going to try to cover some of the high points and just take you through them. But with respect, going all the way back to the introduction of the 2 warning letters from the medical board, with the mayor of Long Beach and the other 2 ladies regarding methadone. With respect to that matter, did you have any kind of a romantic relationship or physical relationship with any of those people in this matter?
Absolutely not.
All right. Now, with respect to your practice, the way it's set up, and the prosecutor, Mr. Ingram, introduced a letter about your resigning your pain clinic aspect of your practice. Could you tell us how you were set up with respect to you, your son, and what exactly you meant by resigning pain clinic?
Yes, sir. I still don't think this is working. My son started practice in June of 2017. When he started, he took over the pain part of the practice. Almost immediately, he began wanting to stop doing pain. And we talked about it numerous times, and at the beginning of 2019, had made the decision that sometime within that year, we would phase out the pain practice and move to just Suboxone only.
Okay, so whenever you said, I'm going to send the letter to the DEA regarding pain clinic, did that mean you were shut down your addictive medicine aspect of your practice?
When I sent the letter to the DEA was when I had closed both practices. I had stopped doing pain really 2 years before that, but we phased it entirely out in March.
All right, what was your policy regarding urinalysis and PMPs? And did you do a urinalysis of yourself, for example? But what was your office policy concerning such testing?
The patients were supposed to have the PMP and the urine drug screen done each visit before they saw me. That was the policy.
Did you do those yourself?
No, I did not.
Well, who was to enact this policy?
Well, Ms. Matthews was in charge of the office, but we had multiple other people that worked there. So most likely at that point in time, it was Nylon who was the receptionist that was actually giving the patients those things and doing the pill counts.
Could you tell us if they gave you the results every time, or whether it was if there was something to be concerned with?
They only told me if there was something that was not kosher.
Did you? I'm sorry, not kosher.
Not kosher. I suppose that's a bad answer. They only told me if something came positive that shouldn't have been there.
What about with a PMP?
Same thing. I would not have known the results of those unless there was something that would have called my attention to it. Up until the time that we got the capability of doing it electronically, then it did become my responsibility, but that was like September of 2019, so it was before this time.
Did you ever tell anybody working for you to not do any testing on TL?
No, I did not.
Did you ever tell anyone working for you, from the office manager across the board, did you ever tell them to not do a urinalysis or a PMP on anybody, or a pill count, or anything like that on anybody?
Absolutely not.
And when I asked the question before, I was referring to all, would your answer be the same if I was referring to all the things you do through tests, such as pill counts included?
That is true. They all were done by the staff, and no, I would not have seen them. They were supposed to be done on each and every visit.
Now you testified about the electronic data and the transfer from a paper file to electronic file. Were there any issues with that transfer that might affect some of the things we talked about today?
The electronic record, in my opinion, is a major disaster and difficult to deal with. Most of what I actually did, I saw on paper, and then I would respond and put it into the records. I was not always good about putting everything in the records. I would put in the present illness, I would put in any exam changes, and then I would document what we did. But a lot of what was being done was kept on paper and never put into the electronic record.
All right. Now, with respect to the electronic record, could you explain about the UAs, your analysis, and the PM or references to the testing you did, whether or not it would be in the, when you have access to the electronic records that may not be in the chart?
Yes, there are many things that would not have made the chart. I was surprised to find that as many urine drug screens were in this chart, which means the secretary put them in before they sent them to me, because I never put them in.
In the electronic?
Right. Otherwise, they just came on paper.
So the fact that the medical chart may not have the UAs reflected in there or other testing did not mean they weren't done.
Absolutely not.
All right. Now, with respect to your relationship with TL, did it start and stay consistent throughout all the time periods relevant here, or was it up and down?
Initially, there really wasn't much of a relationship. I would see him from time to time. The relationship didn't get serious until February of 2018. He did some work for me either late September or early October of 2017, where he remodeled 2 bathrooms for me in my condo. We had discussed prior to that he wanted to begin a construction business, and I told him, okay, I will let you do these remodels. And then after that, we did not do any business dealings until either February or March of the next year.
All right. At the time when he filled out the first application for having an addiction concern, what was the relationship like at that point? What was would it be a more serious relationship or not serious, or how would you scale it, so to say?
Okay, this is embarrassing. It was for sex.
All right. And that's in the beginning?
Yeah.
At the time of the addiction part?
Right.
Now, at the time later, there was a time, a few months later, I believe in October, whenever you testified about the initial information he put into the forms that got carried over because of the electronic thing to the October time.
That is also correct.
What was the nature of the relationship at that time?
He had started on that remodel job, and he was complaining that he was having increasing pain. And I said, well, come on in, let's see you. We'll do an exam and we'll make a decision on what we should do. And he did indeed on October the 17th.
All right, with respect to his complaints of having pain, could you state whether or not you had firsthand information of his actual doing work?
He was working? Yes, because he was working in my condo. I could see him doing that pretty much every day.
Would that be consistent with something that would increase one's pain?
Certainly.
All right. Now, the there was some testimony regarding, early, allowed him to get refills early. And that followed a couple weeks earlier where you cautioned him on being careful about taking the medicine, right?
That is correct.
Okay, now, what, if anything, were you able to observe firsthand that would support that he might need more medicine?
At that time, we were being, I thought, very successful, and he was working 12 to 18-hour days. I knew he was. In fact, I went to job sites relatively frequently. So I did understand that he was indeed working a lot harder than he had. I still wasn't happy that he had overtaken the medicine.
All right, did you tell him about that?
I did.
Okay, and then, when he overtook his medicine, did he take it all at one time, or how did he overtake it?
No, he increased about one a day, and when he called in early, I calculated if he had indeed done the extra one a day when he would have run out, and it was at the correct time, so I said, okay, I will give you a refill.
So, at the time you prescribed and cautioned him about the medicine, and then the time you gave him was it one time, one and only one time?
It was one of them.
Is it your testimony that he had a change of circumstance?
He was, yes, having a change of circumstance. Let me clarify that answer. It was the only time I increased the dose, then it was reduced back to the standard dose after that one visit.
I'm supposed to, so after you gave the one-time increase, you're saying that you then reduced it back down?
That is correct.
Okay. And did you express your feelings about his, what if he ever tried to do that again or needed it in the future? Did you tell him what would happen?
Without any question, he understood he would be stopped off the medicine if he ever overtook it again.
Now, there's a lot of questions about you giving money to TL. First of all, did you pay for his medication along the way?
I never gave him money. I gave credit card information for him to obtain supplies for the construction jobs that we did. From time to time, I would give him cash money for something that he needed to go and do. It wasn't for him personally, it was for the business.
All right, now specifically, along the way, did you ever give him money or did he ever use your money that you knew of to pay for medicine?
Not to the best of my knowledge.
Okay. Now, did you believe him to be honest with you?
Sadly, yes.
Did he tell you about his history the best you could determine?
It was a couple of months after we started the relationship that he told me about being in prison. I knew that before October. I knew that he had been in there for stalking and some other reasons that also included drugs. So I did know that. He was very forthcoming. He told me that. So I had no reason to doubt his truthfulness. When he got married and he stopped seeing me for a while, he told me about that, and I knew about that. When it didn't work out, which was about 3 months later, he also told me pretty clearly what he thought then.
So after y'all started seeing each other, would your relationship being more serious and less serious along the way? Y'all stopped seeing each other for a period of time when you got married?
That's correct.
Okay, and you didn't see him during the marriage?
For about 3 months, I did not see him, no.
All right, and then the marriage broke up?
Correct.
All right, now.
Well, he told me the marriage broke up. There had been some questions raised about a year later on whether that was true or not, but I was still at that point believing pretty much anything he said.
All right, now, you, how many times was a bonded him out of jail situation? How many times did that come up?
Only once. It was a domestic abuse charge. It was 6 months after their marriage had pretty much broken up. And she apparently found him someplace and a fight broke out. He was charged, he was put in, and I bailed him out for that.
And that was, what was that, a felony or a misdemeanor
It was a
charge?
misdemeanor.
Did it involve drugs?
It did not.
Okay. And that was for a much smaller amount. is the second time that something, there's another arrest where he, asked you to bond him out, right?
His final arrest was in July of 2019. He contacted me and asked me, he said his mother couldn't raise the bail, would I help him? And I said I would, and he gave me the bail bondsman to talk to. I called and contacted that bail, however you say that. I contacted the guy at any rate. He said he'd get back with me. He did. He told me what the charges were and what the bail was going to be. And I said, absolutely no way am I going to pay for that.
All right. So although you might have initially started to do that, when you found out the true nature of the charges, you did not.
Right. I had no idea that he had drugs on him, and certainly no idea that he might have been marketing them to others.
Could you tell us whether or not it was at that time that you realized that you'd been conned or deceived?
It started about 3 or 4 months before that, when I actually put a tracker on my truck because of his disappearing, and found that he was lying to me. So the relationship already began to break up. The business relationship had stopped in March of that year, basically because I was unwilling to continue to put out more money.
And did you recover any of your property that was involved in the business?
When he was finally arrested, and could not get out of jail, we had a $30,000 loan at Regions that I had paid off twice, and he reopened. And so I managed to close that down. The Biloxi police contacted me and told me where I could find my stuff, or I think it was them. So I asked them to go with me to where he was living so I could get my truck and the 3 trailers that I had paid for.
All right. And the Biloxi police helped you with that?
They came out there with me. They arranged to have stuff towed off. We went through what we could go through while they were there, because I didn't know what we might find in that.
And could you state whether or not you had good relations with the Biloxi police?
Very good.
Okay. Now, the raid on that day, well, you had put down on question number 9 on exhibit 11 that on your application, when you were asked if there was any ongoing investigation, you said no at first, right?
That is correct, until I talked with you.
Okay. And then you immediately changed.
I contacted them and told them that I had filled it out in error.
All right. So let's talk about whether or not you had, why you did that, okay? Let's describe what happened in the raid and start at your home.
Okay. Early that morning, before I had even had coffee, someone knocked on the door. I opened it. There were about 20 officers. Some were local police, some were state, some were DEA. They put me in handcuffs. They took me outside. I told them my wife was upstairs. I asked if I could, go and wake her up. They would not allow me to do that. They then spent, I would guess, about 4 hours literally tearing the condo apart, looking in air vents, under covers, in closets. I guess they were looking for drugs. At any rate, they didn't find anything. They talked to me in a vehicle for about 2 hours. No, that's probably not right. For probably about an hour. During that time, I asked to see an attorney. They told me I didn't need one. They then transported me in handcuffs to the office. At the office, there were even more agents there. They had posted a sign saying that we were closed, that I walked by, and that we would not be reopened, which was, of course, news to me. Then
Did it have the DEA words on it?
Yeah.
Letters? Okay.
And as I said, this is a building with 2 other businesses, a chiropractor and a physical therapy. So this was posted on the door for That was the common door for everyone.
Were patients coming up to the clinic?
They were coming up to the clinic, they were being turned away at the door.
All right. Do you know what they were being told?
I do not, after the fact I do, but I didn't at the time.
How many people were working for you in your office, or working with you?
At that time, Nyland, the receptionist, Miss Matthews, the business officer, my son Avery, and the drug alcohol counselor, whose name I'm suddenly going to blank on, Holland, David Holland.
Was everybody detained and not free to leave?
Yes,
Did you ask if you could speak to your counsel?
I did.
Was your counsel right there in the parking lot?
You were.
And did they say or do anything to you or about what's going
They
on?
told me I did not need to see you and that they just had a few simple procedural questions they wanted to ask me. At that point, the board's representative was also included,
That's Mr. Gunther?
the guy over there.
Okay. All right, now, and you were in handcuffs this whole time?
No, I was out of handcuffs by that time.
Okay. Now, did they take anything out of your office?
They took some computers, a machine to count money, and they took 5 paper charts out of the office. I don't think they took anything else. They were there about 8 hours and they literally tore the office apart.
All right, so could you say when they took the files, was that at the beginning of the 8 hours or at the end of the 8 hours?
Well, of course, they didn't get them from me because they had me in another room, but it was my understanding they took them immediately.
Okay, and that, I mean, all the things they took out was at the beginning of the 8 hours?
The files were, I don't know when they took all the computer stuff, but I assume it was at the beginning.
All right, so did they tell you that you were under investigation or tell you anything like that?
No, by the time they left, I thought everything was said and done. They had not found any drugs, they had not found anything else. The questions that they had been asking, I thought were all answered honestly and that there would be no additional problems. I was certainly emotional at the time, but that was my thinking.
But they did ask you questions that you answered,
I answered everything they asked me.
all right? Even though counsel was in the parking lot,
Even though you were in the parking lot, they told me I didn't need a counselor.
all right? And did they take the sign down?
They did it ultimately because we reopened for business. Although I think I was too shook up to see anybody that day. I think my son continued to see people.
And so by all appearances, when you answer the question, if you are still under investigation, when they took the sign down and they left after all that,
It was my understanding that the DEA was through with me.
all right? But just to be able to say so, you called me,
I had indeed.
and
Actually, I think my wife called you.
okay, and so you called Alabama and tell them, explain to them what happened.
When I filled out that information, I mailed it back in. Then I got worried about whether I had answered it correctly or not. So I contacted you to ask, should I have considered that as being under investigation? You told me yes. I called them. I told them, that I am under investigation, apparently by the Board of Mississippi, but that nothing had yet happened at that time.
Your office manager also did the same thing?
After the fact, I know that they contacted her and she also told them that there was an investigation ongoing before they did anything. I already had a license in Alabama. I was just reactivating it.
All right. So they were correctly informed,
They were, yes.
all right? And did they renew your license?
Yes, they did in June.
Okay. And they were informed before the board met to decide whether to renew it?
Long before.
Now, there's a prescription referenced by the prosecutor about some pain medication for TL in this proceeding, right?
Yeah, there's been several, yes.
And did you actually observe an injury on TL? that would corroborate the need for that.
Yes, he had a head injury with a laceration of about 3 or 4 inches. And obviously I saw that and knew that he had been to the emergency room and knew that he had gotten a few Ultram.
Okay. All right. Now, with respect to some UAs and other items, our diagnostic tests, but I'm sorry, the blood pressure test, temperature, and the routine things that are conducted. Can you say whether or not you believe that the files that you have received back from the district, from the DEA, do you believe they are complete or not complete?
We've not received any of the paper stuff back from the DEA. As you know, we've asked for it, but they've not sent it. So I have no idea. The only thing we got was what Mr. Ingram sent us, and it was basically patient information and one signed consent.
All right. Could you say whether or not the chart you got back from Mr. Ingram appeared to be complete?
No, they did not.
What appeared to be missing?
Well, all of the loose leaf paper stuff would have been in that chart. So any vital signs would have been in there. The PMPs would have been in there. The lab testing would be in there. None of that stuff made it to the electronic chart on most occasions.
All right. Now, you're not saying that the PMP information Mr. Ingram provided, you're not disagreeing with the accuracy of that, are you?
No, I was very surprised when he met with us and showed how few times that had been done.
With respect to the medical treatment for TL, whether it was by you or another physician, to the best of your knowledge, did that appear that was legitimate treatment for a legitimate medical injury?
Yes, I thought I was doing him the best medical care he could get. I thought I was doing it under all the right rules, even if we were in a relationship. I never thought I was doing anything wrong until we got raided.
Okay, now, but you're not disputing the relationship part, the error of that?
No,
All right. Now, you have, with respect to your office manager and yourself, did you attempt to keep up with the changing rules and regulations by the DEA and the medical board?
as I'm sure every physician that's sitting here knows, those rules were being changed and changed relatively frequently, not only by the state, but also by the national boards of what they would recognize. It was a time where there was a lot of ebb and flow after the CDC published the guidelines for primary care doctors. They began to also apply those to pain clinics, even though that wasn't meant to be the case. So we probably talked to Ms. Francis, I bet 100 times, trying to be sure that we were in compliance with everything that was being asked for.
And who is Ms. Francis?
She's the board secretary that we communicated with.
And what is your office manager's name?
Betty
Is
Matthews.
this her behind me right here?
That's her, yes.
Okay, and how long has she been with you?
Woo! I don't know, over 20 years.
And for all measures, would you consider her abilities and her skills to be exceptionally competent?
Yes, she's been tried, many people have tried to hire her away. She's not been willing to go.
Okay. All right. Now, you have undergone treatment with counseling, correct?
After the DEA raid, I was very upset, very anxious. So I sought out psychiatric care from Dr. LaRue.
All right. And have you attempted to examine the nature of your relationship and its impact on your judgment and what you can do and what you need to do to make sure that that kind of thing never happens again.
Yes, and I also asked her about, and we went over what I had done in treatment, whether it was appropriate, inappropriate, whether, well, obviously transcended boundaries. So we looked at all of those kinds of things. It became increasingly more evident to me that it was really stupid to, one, believe TL, and two, to ever have treated him. After the fact, Visions 2020 at the time, that wasn't the case.
And then, believe it or not, how do you feel about assume that TL was 100% true? How would you feel about your duties as far as a physician treating someone that you're having a relationship with, even if they are the best in the world?
I thought I was doing appropriate treatment like I would do with any other person.
No, I'm not asking about the treatment. The question now is moving to whether or not you should be treating a patient with whom you're having a relationship with.
Well, now I know I shouldn't have, yes. That was a bad mistake.
I want to make sure on this, there's some testimony about that at the end of this now. But you were asked questions about whether or not your charge had a treatment plan in there. Did you believe you had met that requirement to put in a treatment plan?
Yes, specifically, if you want to look at that first appointment on 10/10 of 2017, and you go to the A and P, the plan, there is in there discussions about explaining the risk of addiction. There is a discussion in there about opiate medication, developing tolerance. There is a statement about the fact that they have not been proven to be effective in chronic pain, and that the patient must show improved function, and that the issue of pain is not what we're treating, that function is there, and that if there had been no improvement in function, that the opiate would be stopped. I thought that was a plan. I thought that was adequate. After the fact, it appears that I needed to put specifically what goals were, like walk 10 yards or whatever it was. At that time, I didn't think I needed to do that.
But now you understand you should.
I don't really understand that I needed to do that now. I just know that I'm being faulted for not doing it.
Is the plan different for addiction than for pain?
Basically, for addiction, the purpose is to keep them off of other drugs and to maintain the patient without signs of withdrawal. It is the patient's choice on whether they continue maintenance treatment on Suboxone or whether they slowly taper and come off.
All right, and that's the same for all addictions and all pain.
Yes.
Okay. All right. Let's see. Okay, then I will take it away.
Just a couple of questions before the board members open up for the board members to ask questions. So if I understand correctly, you're not questioning the fact, in fact, you learned for the first time when I actually met you for the first time in your lawyer's office, that only three only three PMP were called in to the program.
You know, I walked in and you told me that, and you know how surprised I was.
Even though every visit, there's a statement in there, ran a PMP and discussed it with the patient.
Because, well, yeah, discussed with the patient shouldn't have been there, but that had been put in and was replicated by the computer each and every time. I thought they were done.
Who do you blame for not doing the PMP
It
query?
is always my responsibility. I am the physician. But up until we got the capability of doing it electronically, I simply didn't do it. I thought the staff was doing it. And I admit that was a bad mistake.
You had talked about the fact that you issued that one prescription early. And you said that, and correct me if I'm not paraphrasing exactly correctly, you said that he was working 12 hours a day and overtaking his medication. What medication are you referring to?
Yeah, bro.
Okay, he's in construction, correct?
Correct, that's our business, yeah, was our business.
And so working 12 hours a day, was he taking it for ADHD or for the stimulus effect of working 12 hours a day?
I assumed he was doing it because he needed to be able to stay attuned to what he was doing and to be focused on what he was doing. Yes, I'm sure it also worked as a stimulant.
You said you've never given him money for medication, but if I understood your earlier testimony, you stated that you didn't charge him for your physician care.
Oh, no, I did not charge him, no, sir.
Okay, so you didn't charge him for being his physician and treating him, but you didn't pay for his medication.
I did not pay for his medication.
Now, are you saying that the medical board investigators participated in the raid in your home?
No,
Just the clinic?
they were at the clinic when I arrived in handcuffs. Okay, well, he was.
Now, sometimes people exaggerate. Are you standing by your statement that you or somebody with your clinic contacted Francis Carrillo 100 times?
I don't know how many, that's probably an overstatement. I'm sure Francis will tell you that we burned the phone up on many occasions.
May get that opportunity. Thank you.
Yeah, right.
Board members have any questions?
Dr. Jackson, David McClendon from Ocean Springs, and the acting chair of the board today. I'm curious, you'd made a comment previously that made me question whether vitals were taken on a consistent basis in your clinic.
On Suboxone patients, generally they were not taken. On pain patients, they should have been.
Okay. Are you not worried about blood pressure in a Suboxone patient?
Unless there was a particular symptom that would have made us concerned about blood pressure, it would have been checked initially and probably 3 or 4 times during the year, but not on each visit.
Do you dispense any medications through your clinic?
I do not.
Any other questions from board members? Dr. Miles?
You say that on your drug patients, on your opioid addiction folks, you did a urine drug screen and some of the things, but you didn't see that on the record before you saw the patient.
They were done before I saw them. They were done before I saw the patient. I would not have seen them unless they were positive for something, and then they would have been brought to me before the patient was brought back. We were doing immediate readings in the office.
Did this always happen? I mean,
Yeah, always.
always? Okay. We all have to do the EMRs, and we know they're a pain in the rear.
Yes, that you do.
And a lot of times you come to the office and one of the terrible things you can hear is the computers are down.
Well, yeah, we
And
couldn't
then-
do anything when that happened.
And so then we all have to keep paper records. At the end of the day, when the computers come back on, whose responsibility is to put that data back in that chart?
Mine.
What do you consider to be your actual medical record? Is it the paper chart or the EMR?
I work out of the paper. I try to convert that into the EMR. I am not always good about putting everything into the EMR. You know, you're all physicians, you know, when you're busy and things are happening, you don't always remember to enter everything in. That one prescription that was given that he mentioned that didn't have an entry had to have had an entry done because it was printed out of the computer. But if you hit the wrong button, which unfortunately I did on more than one occasion, it will completely erase everything you did. And I assume that's what occurred in that one particular one where there's written documentation that I actually wrote that prescription and didn't call it in.
That's probably why God made nighttime, so you can stay in that chart, stay in that office and transfer that data over. And sometimes it gets to be late, but you and I both know we're responsible to do that.
I do know I was responsible. I knew I was responsible for the phone and stuff too. You know, I just either didn't or it was in the paper chart. I don't know which, probably didn't.
Okay, thank you.
Dr. Joyner.
I need to clear something up for me. You didn't know whether the PMP or drug screens were performed because the folks up front were supposed to do them. And if they weren't sending you the results, you didn't even know if they were done, did you?
I guess not. I mean, they were
would you
supposed
think
to,
that's
that
a
was
really
the
good-
policy, but I don't guess I would have known if I didn't look.
You think that's a good way to approach taking care of pain patients and addiction patients?
Hindsight is 20/20. I've learned a lot of things that I did that wasn't necessarily the way I would do it now, you know. And that's certainly one of the things that I would have done differently. But at that time, I thought I was doing everything that I needed to be doing. I thought I was doing it right.
But everything that goes on with that patient is your ball of wax.
It is my responsibility, so if it didn't happen, it's my responsibility.
Dr. Lippincott.
Dr. Jackson, could you tell me about what your residency training was and where?
I did my residency training at Emory School of Medicine in Atlanta. I initially did a psychiatry residency. Then I did a brief period of time where I did an internship in internal medicine before I went into the neurology program.
And you're board certified in psychiatry and neurology?
Yes, sir.
But you primarily practice neurology, is that correct?
The reason that I moved into neurology after 2 years was because I really didn't like psychiatry. So yeah, I did consult psychiatry periodically, but that was not my gift. And neurology was much more akin to the way I do things.
But you consider yourself a psychiatrist?
I do. I have, from time to time, done primary psychiatry work. Generally, it's been on locum tenens and it's been in jails. And under those contexts, I don't have near as much of a problem because I can control everything. Out in the real world, that's just not the way it is. So, yes, sir.
Okay.
Great.
But you're comfortable making a diagnosis of ADD from a mental status exam?
Absolutely. I used to be consulted a lot when Sand Hill was Sand Hill and not Memorial Behavioral Health Care on the children. And much of those consults were whether or not I felt that they had a neurological issue or whether they were indeed ADHD. So yeah, that was a common question. I feel comfortable
So
in
could you
making that
explain,
diagnosis.
so could you explain to me how you make a diagnosis of ADHD?
How you do it, you make it by the history, and you make it by the observation of distractibility, impulsivity, and of course, their ability to maintain attention. Even some of the mental status like digit recall, memory recall, you pick up some of that inattentiveness.
So do you think ADHD is a psychiatric disorder or a neurological disorder?
I believe it's a neurological disorder, yes, sir.
Okay, and are you a member of the American Psychiatric Association?
I am,
Are you aware of the Code of Ethics?
yes, sir, I am.
What does the Code of Ethics have to say about relationships with patients?
It was a bad mistake.
You have medical liability insurance,
I don't anymore, I did then, yes, sir.
and does the medical liability insurance have any policies about sexual boundary issues that you're aware of?
I don't know, I'm not aware of that. I would think so. I know that's why I haven't been able to get the locums jobs, or because of malpractice not being the locums, people's malpractice would not allow me to until something was done here.
Well, just for your information, it's my understanding that the APA's Code of Ethics prohibits sexual relationships with patients, and that the liability companies typically don't cover those transgressions. Just for your information,
I am aware of that, yes.
and that's all I got.
Dr. Reddy?
Thank you, Mr. President. Dr. Jackson, I'm Dr. Dan Eddy from Vicksburg, and I practice internal medicine and addiction medicine. First of all, TL, as a patient, he reported, had a history of using stimulants.
No, sir.
He said on the intake, he self-reported that he did.
He self-reported that he had used them, yes, sir, not that he had abused them.
So with he, on that abuse history, when he said all, said it not include cocaine, methamphetamine.
He had used methamphetamine in the past, yes. He had not used cocaine. I think he was being a little bit superfluous when he put all.
So do you think it's appropriate, safe to prescribe Adderall to someone with a history of stimulant abuse?
If it's carefully watched, yes.
Are there alternatives to stimulants in the treatment of ADHD?
There are certain drugs that are primarily blood pressure medications that are sometimes helpful. Antidepressants are sometimes helpful. Wellbutrin particularly is sometimes helpful.
Did you document in the record why you made the medical decision under your discretion as a licensed physician to prescribe stimulants to someone with a history of stimulant abuse? Did you record your decision process and why you did that?
Not adequately, no, sir.
And did you record your decision making of why you chose to increase the dose specifically after? I want to get that clear.
Okay.
You're defending your decision, but did you record your decision making, medical decision making, and why you were making a medical decision that was contrary to general course of action for a physician?
Yeah, I can't find precisely, but I most definitely put in that, this was an early refill, that it was going to be a one-time thing. So yes, there was documentation that that was done. There was a whole lot more than that said, because that was one time when I really got angry at him.
Did you document why you chose to make that dosage change? And why to do it early and why to increase the dose?
I think I did, yes, sir.
So you can show that to us.
I don't
You
know.
don't have to right now, but you certain it's in the record and
There is in the record the discussion and the documentation that it was an early refill and that the
what I
reason,
heard was that you kind of did that on the fly. That you did an early refill and increased the bill count. That was not during offices.
no, it was
That
not.
was the testimony I heard.
No, that was about the text. And the text was because he had asked me to do it and I had not done it. But it had been done in a visit.
If your attorney or you can find that documentation, I won't continue asking questions because we've been here a long time.
Yes, sir.
Okay.
Yes, sir.
Is it ever safe and appropriate to prescribe full agonist opioids to someone who clearly has opioid use disorder? Do that safely and effectively.
In the setting of an acute injury and limited amounts, yes,
What do you consider a limited amount?
14 or less,
Who prescribes the 30 Percocet?
probably me. That was after the head injury.
Is that a limited amount?
That's not a limited amount.
So is that safe and effective for an opioid addict?
I thought it was at the time. Now that you pointed out, no.
And you're delegating a lot of work to your staff. You have RNs or LPNs,
Yes, sir.
so you're delegating your work to non-licensed people.
I'm delegating doing the urine drug screen and the DMP.
Sounds
Yeah.
like you're delegating the interpretation of those as well. They're screening it for you, and they only tell you what that is, right?
Right. Two different people have to sign off of it, so
Who's deciding is that normal and that the physicians should see it?
if it's positive, then I'm to see it.
Who's determining if it's positive?
They are when they do it.
Are they licensed professionals?
No,
Whose responsibility is it to interpret the lab test?
a lab test would be me.
Is it your drug screen not a lab test?
I mean, it's either positive or negative.
And you have to interpret whether it's a false positive or a false negative, and if it's unexpected, why it's unexpected.
Correct. That would be my responsibility to do.
Were you billing for those? Were you billing insurance for those tests?
We didn't bill insurance, so no.
Did you ever bill anybody for the urine drug?
Yes, everybody had to pay it in advance.
So don't you think they were paying for a doctor to read that test and interpret that test?
I guess I didn't see it that way, but yes.
And the same thing's true for the PNP. You were reporting in your record that the PNP was looked at and reviewed with the patient. That's what I heard you read from your record.
Yes, that was in the medical.
How can you review a PNP with a patient that you haven't even seen?
Obviously, I didn't.
So you were falsifying the record.
I wasn't intending to. That was one of those electronic record things that just got printed.
No, we're not gonna do that.
Okay,
We're all working with electronic records.
it
So
should never have been put in there.
So explain to me why you're reporting evidence into the chart that you know is not true. You did not review those PMPs with the patient. That's a false statement that you entered into the record.
Okay. When the first ruling came out, we were getting the PMPs and the patients actually saw them. That was when that statement got entered into the electronic record. As time went on, I stopped looking at ones that weren't positive and I stopped going over them with the patient. And it indeed would be falsely stated if I said I did when I didn't. It was not my intention to mislead. It was the stupidity of not going back and looking to see whether I'd taken out stuff that should have been taken out. There was a lot of stuff when I went back that I looked at and said, this is crazy. Why is it still being repeated? You know, I'm not a perfect person. I thought I was doing what was right, but I don't think I did it as well as I could have.
And you're board certified in how many specialties?
Psychiatry, neurology, pain management, acupuncture, EEG, evoked potential, sleep medicine, and EMG.
And so when you decided to slow down your practice, you left the areas of medicine that you have been trained and board certified in and went into a field that you're not trained or board certified in. Why would you explain that to me? Why you're boarded and rightly proud to be boarded over here, but you're practicing in an area that you're not?
And you do know I was in a plane crash and had significant injuries.
No.
No, I'm sorry. I had a plane crash. I got burned over 60% of my body. I had an L1 compression fracture, a knee that had a tibial plateau fracture, and bilateral ankle injuries. I returned back to practice about 3 to 4 months after in a wheelchair initially. But after about 5 to 6 years, I just couldn't do it anymore. I couldn't do the consultation. So I started looking for other things. That's when I went to get trained in acupuncture. And we did extensive for a long period of time, acupuncture as a pain modality. The addiction stuff actually started because someone asked me to do it, and I did the initial 30. I considered that part of my training. In fact, I would have stood for the board, except there was some stuff that got messed up in the application for it. And by that time, I decided I was too close to retirement to go through that. But
Because I would tell you that if you were board certified, your training would tell you that it's very dangerous to prescribe Adderall to anyone with a disease of addiction because of cross addiction.
I wouldn't disagree with that. Sure.
And that it would be malpractice to give 30 Percocet to an opioid addict.
If you say so.
All right. And then finally, I just need to clear this up. Final question, clear this up in my mind. When is the first day you had sex with GL who addiction became a patient?
Sometime in July of 2017.
And so when you entered into the doctor-patient relationship, you had sex how much?
Maybe 3 or 4 times.
It was very clear you had a sexual relationship. It was very clear you were entering into a doctor-patient relationship.
Yes, sir, I understood that.
Okay, thank you.
Doctor, I do have a couple of other questions. Similar situations of licensees having problems like we were seeing with you. If those physicians want to continue to practice medicine, we have a very formal process of discipline and re-education in the rehab process. Certainly, it's a positive thing that you're seeing a psychiatrist, but there's going to be a whole lot more if the board finds favor in finding a rehab plan for you. There's going to be a lot more to it. And so you've had a long career. And so do you want to practice medicine strongly enough to continue with this process?
Yes, sir. I don't want to ever go back to full-time practice. I don't ever want to go back to pain. But I really enjoyed Suboxone, and I have looked at doing that like 10 to 12 hours a week since I retired, through a local tenants company. So yes, I will do whatever I'm mandated to do. I know I goofed up. There's never been a question about whether I goofed up. I goofed up. The question was whether I necessarily was not practicing medicine the way I should. I thought I did, but I see all kinds of mistakes I made now that I didn't really recognize then, particularly things like routinely putting in that the PMPs were being checked when I didn't do it. I mean, there's a lot of things I did wrong.
Any other questions from the board?
Just one thing, Dr. Miles. You do realize that for us to get you through our routine rehab situation for your problem is the same rehab situation as if somebody's going back full-time as a general surgeon. I mean, we don't have a rehab situation for somebody gonna do something 12 hours a week. We don't have that. You either practice medicine or you don't practice medicine. I mean, that's the option that we have. Just want to make sure you understood that.
Okay, I think I understand what you're saying. Yes, sir.
Okay.
Are there any other questions?
I have none. If I may, and having represented the doctor, I think he tries to answer questions precisely, and sometimes he's thinking, giving an answer that's not exactly, it's a truthful answer, an honest answer, but it's not fitting the question. When he says that he is not going to go back full time, obviously he's still practicing medicine, and he definitely would be grateful to be able to take any kind of program, that the more intensive psychiatric program, to deal with the issues that of patient relationships, which gladly, and he understands that, and understands that he would endeavor to do that and complete it. Although, on answering the second part about would he be willing to do that with his practice? Well, definitely, he wants to practice medicine, and even if it's a lesser amount, he wants to do. He would greatly appreciate the opportunity to do that. But there was one thing I wanted to follow up with the doctor based on some questions you asked. One area for me.
Briefly, please.
Yes, ma'am. With respect to your plane crash and the burn, did it cause you to endure a considerable amount of pain?
Yes, I'm still in a considerable amount of pain.
And did that experience, from your perspective, put you in a unique position to be able to understand pain in a way that you believe would help you be able to be a good pain specialist?
You know, people who knew me before the accident, people who knew me after the accident said there was a definite change in my ability to have empathy. You know, beforehand, none. Afterhand, apparently too much.
Yes, sir. I tend to agree.
Thank you.
I'm going to briefly call Dr. Randall Sherman as the next person.
Dr. Sherman, you've already been sworn in, correct?
Please state your name for the record, please.
Randall Sherman.
And what is your profession?
I've had two, neurosurgery and addiction medicine
How long have you been a licensed physician?
since 1979.
So your specialty would be addiction medicine and neurosurgery.
Yes.
How long have you been practicing addiction medicine, did you say?
I practiced addiction medicine for about 12 years, and then I retired fairly recently.
Looking for your CV. Board certified?
Yes, sir, in neurosurgery and addiction medicine.
Did you take your CV and basically just summarize your experience, your areas of practice and so forth?
Okay, I graduated from University of Oklahoma Medical School and 1978, and then I did a 6-year neurosurgery residency at Loyola in Chicago until 1984, and then I practiced in an academic and private practice in Pittsburgh for about 6 years, and then moved from there to North Carolina, where I was in a purely private practice for the rest of the time up until 2004. At that time, actually just personal history, not on the CV, I got into recovery from alcoholism, and which was how I got interested in addiction medicine and decided to shift gears. Fortunately, I was able to afford to do that at the time, and so I did a fellowship in addiction medicine that was sponsored by the University of Florida, and then practiced in Hattiesburg and Pine Grove.
How many years have you practiced addiction medicine in Pine Grove?
About 12.
I'd like to tender this witness as an expert witness in the area of addiction medicine.
No objection.
Before you continue, do you mind spitting out your gum? We're having a hard time.
Yeah, I'm sorry.
That's okay, thank you.
I'm going to introduce Dr. Sherman's CV as the next exhibit, which would be 13. You've been in here the entire morning and mid-afternoon, is that correct? What, listening to the testimony?
Yes.
Okay. What documents have you been submitted to render your expert opinion here today?
Well, I had the patient record, the electronic medical record, and the PMP.
Did you have also the accusation or the complaint, if you will?
Yes, sir.
What we call the admitted complaint.
Right.
Okay. And you've heard the testimony. I'll just go ahead and get straight down to the bottom line. You've heard the testimony of the good doctor and the allegations that because of his romantic relationship with patient TL, he failed to exercise objectivity. Did you find that to be the case during your review of the documents and witnessing your testimony today?
I would agree with that.
Okay, can you elaborate as to the opioids, testosterone, and the amphetamines, or the Adderall, and the buprenorphine?
Well, yeah, Dr. Edney hit on a number of things that I was thinking, but to me, Suboxone, buprenorphine, it is primarily for treating addiction, and as opposed to pain. And to treat addiction, it's always been my understanding that the standard of care in maintaining someone on Suboxone is to have them off of all other mood-altering substances, certainly all narcotics, and have them just taking Suboxone and be frequently monitored to make sure that's the case. And then if that particular treatment fails, then to take some other avenue, go to inpatient treatment or some other form of 12-step treatment that doesn't involve Suboxone. As for pain, I've got a fair amount of expertise in the field of pain. I don't think there's any such thing as a pain expert. But as a general rule, opiates, any kind of opioid, is to be avoided, even in the best of circumstances, for chronic pain.
it can be used, they're designed to be used briefly for acute pain or in the circumstance of terminal pain that comes from malignancies, for example. But they're about the worst thing you can do for chronic pain, and certainly the worst thing you can do for an addict is to add opioids.
Is there any legitimate circumstances under which, let me back up, when you look at the record, Dr. Jackson jumps from opioids over a period of time, then Suboxone, back to opioids and then Suboxone. How do you react to that?
I didn't really understand it. I mean, I know Ultram, tramadol is used sometimes for detox from opioids, in particular Suboxone, not just long term. And Ultram is, in spite of its initial touting as a non-narcotic, is most definitely a narcotic. It's a mu opioid agonist, and very addictive. Patients in treatment all the time for tramadol addiction. Yeah, I didn't understand that. I didn't really understand the steroids, the testosterone and the various other Arimidex and clomiphene and all of that in a 20-something year. I know a chronic opiate use can lower testosterone, but I didn't see a testosterone level, and again, I don't understand. I mean, I know that those combinations, testosterone and some of those estrogen blockers, are used by weightlifters, in bodybuilding, but I certainly never have used any of those myself, prescribed any of those myself in addiction treatment.
If a patient comes to you and requests testosterone, you being an addictionologist and neurosurgeon, say neurology, who is best to make that decision? Referral to a urologist? Would that be the appropriate course?
That's probably what I would do. I mean, I would check a level and see if there was an issue first, and if there was, then probably.
Did you find, I think you hinted to this moments ago, is there anywhere in this record where a level was recorded?
I didn't see one.
You heard Dr. Edney's comment a moment ago. Is there any circumstances under which you prescribed 30 Percocet to an addict?
Well, no. Certainly not now. Although admittedly, in years past, it seemed like if you were going to prescribe Percocet or Lortab or one of those for an acute injury, 30 was kind of the standard amount you could give. That wasn't unusual, but I wouldn't do it to an opiate addict. I wouldn't give them Percocet.
In fact, if you recall, the record shows that shortly after that prescription, he came back almost the next day after acknowledging taking 2/3 of those Percocet. How would you react to that?
Yeah, I don't. Opiate addicts can't control how much Percocet they take. That's what addiction is.
You've heard the testimony. I would like to receive your observations concerning the objectivity in choosing to prescribe the Adderall to a patient that's openly an addict and also taking other medication too.
Yeah, I think that was touched on previously too. I'd be very reluctant to use any other narcotics in treating an addict. ADHD in an adult. I think, at least when I was working in Pine Grove with a number of other psychiatrists, most of them didn't even believe it existed, or if it did, it was pretty rare. And would never recommend treating it with Adderall. In all the years I was there, we never used an amphetamine to treat symptoms of ADHD. We used other methods, therapy and Strattera, various things.
So, based upon your review of the records and the testimony you've observed today from Dr. Jackson, do you believe he exercised objectivity in making the choices he did when treating this patient?
It doesn't seem like it.
The board members, well, consider the witness.
Hello, Doctor. Hey, Michael Crosby. Is Adderall a narcotic?
Yes.
Okay. Schedule 2?
Yes.
All right. And isn't it true that chronic pain or chronic pain will oftentimes be treated with opioids?
It's not recommended.
But oftentimes it is, though, right?
Yeah.
Okay. And do you know a lot of doctors over the years and how their treatments and opinions can vary, right?
Yeah.
And then older doctors had a tendency to use more pain medication than the more current doctors, right?
I know. I think older doctors, I don't know what your definition of older is, but you're talking about my age, we tended to use less opioids, and it was back in about the mid-90s that Purdue Pharma managed to convince the whole country that opioids should be given to everybody that uttered the word pain.
And thank you. That's exactly where I was going with it. And I don't mean to suggest or say anything when I say old. I'm trying to use it as a doctor who practiced medicine years ago. And I was going to get right to that point. And that is that it was just the pharmaceuticals beat it to the heads of the doctors that like Oxycontin. It's going to be the cure all for pain with no addictive problems. They convinced the doctors of that. And then but then they found out, of course, things changed along the way. But you can't agree that doctors who have been practicing medicine for many years and many years ago, that all that has changed, and that is becoming more conservative with the pain medication.
It is.
And we know that Dr. Jackson's been practicing medicine for a very long time, right? And while it is absolutely improper to have a relationship with a patient, but could you agree that a doctor who's got a relationship would be in a position to make firsthand observations about their responses to medications?
Yes.
And we know Dr. Jackson was in that position to observe the reaction and whether or not the medicine he was prescribing was being effective.
Yes.
But I tend to agree with you. Thank you.
Is the old school approach the appropriate course of action?
It's the well-documented approach.
Do the board members have any questions?
No.
Okay, thank you so much.
Can I make a comment? Some of us older doctors try to keep up with what's going on. Don't get sucked into Purdue, and we made adjustments along the way. Thank you.
I certainly reserve the right to call witnesses on the rebuttal, but at this point, I tend to no further witnesses. Rest my case.
I will call Betty Matthews. May I proceed?
Yes,
Yeah, okay. Now, please state your name for the record.
Betty Matthews.
Okay, I may ask you if you maybe pull the mic to you and pull up to it. You're a little bit taller than most of the witnesses.
It's Betty Matthews.
Thank you. And you've been sworn in under oath, correct?
Yes, correct.
Okay. How long have you known Dr. Jackson?
Over 35 years.
Is that about how long you worked for him?
Correct.
All right. Now, in your office, would you describe how it's made up? You know, who works there, who's part of his clinic and pain management and addiction medicine, and just kind of describe some of their training and education and diligence to the job.
There's a total of 4 of us with the doctor. I have Nile, and she's a certified medical assistant.
And that's who?
Nile and Rowley.
Okay.
She's a medical assistant. And before her, we had Amanda Fales, who was medical, and she's working on her RN. And we have Dave Holloman, who is a licensed addiction counselor. And he's had extensive training in another state. And also we have Dr. Jackson's son, Avery Jackson, who's a nurse practitioner.
All right. And does your staff get any kind of certification in drug testing?
Yes, we do a certified training that we do online for interpretations of the urine, along with, we do a lot of send out drug screening.
All right. So what is a send out drug screen?
It's a confirmation. It's quantitated where we send it out to a lab that's not associated with us. And if we have a positive, the patient always has the choice to have it sent out. According to requirements, we send them out randomly anyway, just as a backup, because no office is perfect. So we send them out. We don't just count on what the office does.
All right. And what does your office do about pill counts and PMPs and about the testing, kind of the tools used to prove the veracity of the patients and the legitimacy of the patient?
We have in our policy that they sign coming in that we do random drug screens, random pill counts, and we make good attempts to call them. A lot of times they don't come in. We're required to run PMPs, as was previously stated, when it's ran. If it's a red flag, we put it on the chart. If it's a positive, we put it on the chart. We notify the doctor, and we let the patient know and give them the chance to say if they want it to be sent out or not. We always try to get their permission. Sometimes they agree to it and say no, because a lot of times they're paying cash. A great deal of them don't have insurance, so we have to get their permission. And there's protocols that follows that in terms of what's going on. But for the most part, we try to get them born. As I already mentioned, sometimes the computer's not working, things are down. Sometimes the PFP reports are down. Sometimes if the patient name is not spelled correctly at the pharmacy, doesn't matter how we have it, a PMP report will not generate because it's going to tell us patient not found.
Okay. Do you have meetings to help determine how you're supposed to handle patients and to improve the quality and procedures of the office?
We do. We have meetings throughout the year to talk about if problems came up, to talk about, what we do. We've tried to, over the years, address how we can get patients to be compliant with calling. You call them, they give you a number. Sometimes when they leave, they change. I found out recently, they have a ability to change it so that they can't get called. And of course, eventually they are dismissed because after so many calls and they don't show up, we can't continue to treat because they're not compliant.
Have you ever been told to not do any kind of testing?
No.
Or to your knowledge, has anyone in the office ever been told by Dr. Jackson that you should let someone slide?
No.
What about specifically on TL? Do you know this patient?
I know of him. I know he was a patient.
All right. And have you ever been told to cut him any slack in any respect?
No,
Did you treat him the normal way you would any other patient?
yes.
All right. Can you describe any issues you have with the electronic data regarding the charts?
So electronic medical records, as good as it is, one of the problems is whatever you enter in a template, it is going to automatically pre-populate. For instance, as mentioned about that statement that you have reviewed the PMP, that statement was only entered in template late 2019 due to some of the new changes about how often you should check the PMP. And so it was just brought to my attention this week that that is an issue, because I noticed if you go back to 2018, that statement is populated there, and it was not put in the electronic record until the end of 2019. So, and like we changed the name of the clinic. So whatever record you print today is gonna reflect the current name, and it's not gonna reflect that it was a patient of Dr. Joey Jackson. And that has posed a problem if it's a litigation. So if you have a civil suit or an accident and you send those records out, well, now they're gonna go, hey, wait, they didn't disclose they saw the new name. They didn't see the new name. It was under the old name. So that's a problem with EHR.
All right. Now, some of these, there was some conversation today, testimony today about the fact that the charts presented in evidence did not have some testing. Do you know whether or not any testing was missing from the file chart?
In relation to TL chart, there should have been some handwritten urine drug screen. That's a point of care. We do point of care. It is handwritten. And of course, it's filed by my receptionist, but you know, after that raid and stuff, we talked about that. And there should have been some urine drug screen, but they came in, they took all the charts at once, and there was a lot of paper. So I don't know what happened to it, but there should have been some urine drug screens in that chart.
All right, what about the way it's set up now with electronic data? Do you have things on the data that may not be in the chart? I mean, electronically available that may not be in the chart?
So there is a possibility that there's electronic stuff in the chart. In the electronic chart, because once they decided that we should mandate electronic, we moved toward trying to do less paper as possible. For instance, some of our lab, we had the ability to dial into Singing River Hospital, Memorial Hospital, and Merritt. We can view, a lot of times the doctor could view what was done and make a note of it versus us printing it. And with electronic medical records, you have to have a scanning process, and it has to be a specific process to get stuff into the chart. And we eventually, over time, instituted, we paid for a gateway scanning service where whatever we scanned in went directly into that chart. But yes, there are times where there's stuff in the electronic record that's not going to be in the paper because we were trying to move to paper. And also with the electronic record, I don't know if they've noticed, but when you click, if you click on something that was 2012, 2011, you're not going to see it in the electronic because the cloud has purged it. So you get an error that says they are trying to pull old records, and in a day or so, a lot of times you can go back in there and it's there. That's something, you know, over the time we've discovered different problems coming up with EHR that you're not going to be aware of when you're actually doing it. It's happening kind of on the back end.
Now, what kind of time would you and Dr. Jackson spend, if any, on trying to keep up with the changing rules and regulations?
Oh, a lot. Anytime, if someone came in, and usually it was a rep letting us know about a new medicine or a patient, or we heard or it was on the news that there was some pending change of some new rules, we always call the medical board. I have had numerous conversations with Ms. Francis, who would send me to the guidelines. She would say, Ms. Betty, I want to tell you where to go. This is what they are. A lot of times the guidelines have been proposed, and she's the one who explained it to me. They are first proposed, then they are adopted, where they have to go before public review. If there are no changes, then they become official. And so, but over the years, they've changed a lot. And from listening, you know, we did what we thought was our best explanation of it at the time.
All right. even, could you state, what your understanding was about the PMP being mandatory or not, and when it changed?
So my understanding of it was that we know our proposal came up sometime around 2018. And that was when there was the whole proposal with whether or not to prescribe methadone, which was later taken away, whether or not benzos and pain should be done, how often you should do the PMP. So at that time, it was our understanding that it was every 3 months or every encounter. And so that's what we were doing. And then later, as we realized it was about to change to every time, we started beginning to make that change. Dr. Jackson had just went to an extensive pain meeting, which was required for his pain clinic. And there was a lot of discussion about it at that meeting. And he came back and we placed a call to the board. In fact, I think we also talked to Dr. Brunson at that time because there was a big discrepancy on, yes, you could do this and no, you couldn't. But we immediately put up a notice on all our windows to all the patients, letting them know that we will begin to check PMPs on every visit. And so going into the end of 2018 into 2019, we did that. And that was at the time after he came from that meeting that we contacted Amazing Chart and asked them how could we get the ability to, he would check the PMP and the chart will automatically document it. So that's how that description is. And we paid for it because you have to pay for that integration. It took them a long time to get it in place. It took too long. We had paid the money. 3 months later, we still had not gotten the ability for automatic documentation that it was being reviewed. So it was a lot of going back and forth with that rule.
Okay. Now you met in my office with me and Mr. Ingram, and we talked about various things, right?
Yep.
And one of them was the PMP entries, that's reflected in TL's file, right? Did you?
Yes.
What is your understanding about, how would you address the issues of the PMPs in TL's case?
Well, obviously they wasn't done. And like I said, it was done on the front end. And so I can't say whether or not it was an oversight or that it was attempted. Like I said, sometimes if our spelling do not match what the pharmacy, sometimes, and we discovered this because of repeated, not just one patient, many patients who we knew was getting medicine from us, but their PMP was saying they were getting no medicine. So I would make a call to the pharmacy and say, hey, why is this patient getting medicine from you? He would say, yes. I was like, well, are you aware that your PMP is not poorly? We have one pharmacy in particular, they changed theirs, they started. The PMP should probably document, if or not it was attempted, I'm not sure. So that could be the reason, but I'm not 100%. So it was just a lack on the front end.
All right, now, you heard the testimony about the question 9 on Exhibit 11 for the questionnaire to Alabama. You're familiar with that?
Yes, I am.
And there's a question where it's asked the applicant, are you under investigation, right?
Yep.
And the answer started out as no, correct?
Correct.
What if anything, if anything, did you have to do with any changes in that response?
After Dr. Jackson discovered that, he did place a call to me, and I also called the Alabama board. You call, you get the switchboard. She transferred me to the lady who handles the relicensing and licensing. And I explained to her that on that portion, he had originally said no, but we wanted them to be aware that he was currently, that he had had a visit by the board and the DEA, that at that particular point, no decision had been rendered, but he probably was under investigation, and we wanted them to be aware of it. And she said, thank you for telling me. I'm going to let them know before they meet. I said, but I want to be sure. And it was my understanding that I also sent an email because the DA had been there. You can't track words that you say, but you can track an email. So I'm pretty sure that I sent her an email so that she would have that in writing to make that change.
But you can say it on your sworn testimony for a fact, they were told before that their Alabama
Yes, absolutely.
board met. All right. I tended to win.
Would it surprise you there are 36 office visits noted in that record?
No, I mean, I haven't looked at it.
I counted 3 urine drug screens. Does that surprise you?
That does surprise me, yes.
And you say that you go to the guidelines, did you say that Francis Carrillo told you to go to the guidelines? Or you discussed the guidelines?
Yes, she would always direct me. In fact, while I was on the phone with her, she would walk me through where to find the guidelines that whenever we had a discussion.
That's correct. In fact, she told you, go to the board website to get the answer.
Right, that's what I told you. She would send me to where to go to get the answer,
And
correct?
it's the website and the current rules in effect that control. Is that correct?
She would send me to the, now, when we talked, when it became a big issue, she said, you can, and when I printed it, I said, it said amended. And that's when she explained to me the step of how the guidelines are adopted, or finally
That's the
adopted.
procedure.
Correct,
The bottom line is to what the guidelines say, go to the board website.
correct.
Thank you. Board members?
Any questions?
Are you saying that there were PMP checks and urine drug screens in the paper chart?
Not PMPs, urine drug screens. There should have been handwritten, our point of care drug screens is a sheet of paper and we mark it. And there should have been, at the time of that raid, there should have been urine drug screens. So the fact that we didn't hear anything from the DEA, our office discussed it. We knew that when we do paper drug screen, we try to put them in the chart. So there should have been urine drug screens in their chart.
Any other questions? Mr. Crosby, do you have any other
Oh,
questions?
no, ma'am, I'm sorry. No, ma'am.
Thank you.
We rest.
Okay.
I have a 5-minute break. I want to find out if I'm going to call anybody else. I don't think I will. I just want to make sure.
Yes, we'll recess for 5 minutes.
5-minute break?
Yes, sir. Still take the break. Go ahead.
We are taking a break.
Yeah. Yes, we are. You see me looking at them. I love feeling up and get them. Thank you.
What you think? I don't want you to be looking at
Barbecue ribs.
That's it.
Circular living cot in the bathroom. We'll resume session.
We're ready for closing. Proceed.
All right. The last thing I'm going to do is start going over all of the evidence that's been introduced. I'm not going to do it. What I will say is that when you go into executive session, you've got 13 or 14 exhibits that you can wade through. Most importantly, the prescriptions and the medical records. It is interesting that all of the failures, whether it's the urine drug screens not in the record or the PMP reports, it's electronic medical record problem. You know, ladies and gentlemen, if Dr. Jackson is the captain of the ship, he or his assistant cannot blame all of their woes and all their problems and all their decisions and failures on the electronic medical record. The case is clear in this case. Undisputed expert testimony, I might add, that when you have a sexual relationship with a patient, there is a loss of objectivity. And I believe when you look at all of the prescriptions issued, the ones that were filled early, the ones that after the patient said, after he told the patient TL to not take any more of drug A, he turned around. If he would have checked the PMP, he would have found out that after issuing another prescription, which would be contrary to that, he continued to fill the previous prescription. So the problem with checking the PMP is that he didn't do it at all. And you heard the expert testimony, again, uncontested, that you don't treat a patient in this manner, and there was total lack of objectivity. Now, it's undisputed he had this relationship. And obviously that's going to be one of the primary factors. But don't lose sight of the fact that the evidence shows that he didn't manage this, regardless of what he said, he didn't manage this patient appropriately.
Ladies and gentlemen, there's a difference between blame and explain. Dr. Jackson is not trying to blame anyone or anything, but he's trying to explain what happened so that you will know. Does he agree that he's responsible? Absolutely. He's always been and always was the captain of the ship. And he had people who had been with him for a long period of time who he counted on and who tried to understand what their requirements were and who did do what they believed was right. It's not necessarily undisputed expert testimony because Dr. Jackson is an expert, but he agrees, of course, that the relationship was wrong and everything about it was inappropriate. Everything about it. And the question is, what do we do for a man who has gone this far and been able to do so much? You know, so he's a very important part of the community, and he provided a service that was very important in his community, and he did it with pride. He did it with efficiency, and he had his trusted longtime staff who made sure they had the meetings to make sure what they were doing was the best possible medical care that they could provide. So is what he did wrong? Absolutely. What do we do with him? That's the question. He is willing to do whatever it takes because he does not want to go out with this failure on his career. And of course, it doesn't matter what he wants, but the question is based on his long time being a doctor, his many board certifications, the high quality of everything else other than this horrible mistake he made. The question is, what do you do with him? Do you throw him away? Because right now, he's going to be in your hands. Everything this man has ever worked for, everything he's ever tried to accomplish, everything he ever dreamed about, everything he made to the end of his career is now in your hands. And now you got the power to crush him out. Or you got the power to say, you know what, doctor, you admitted your mistakes. We still see good in you. If you're willing to do A, B, C, and D, and give it your best, we can monitor what you do. We can keep up with it. We can get reports and make sure what you're doing is that you've given it your best. And you can give him a chance to help redeem himself. Because we all in this country, we believe in the ability of people to redeem, the people to admit their mistakes, and everybody makes mistakes. But for the grace of God, because of how we're born, how we're created, we will go lean one way or lean another way, and those leanings can cause us to make mistakes. But he made this mistake. He would greatly appreciate an opportunity to be able to prove himself to each of you, and to his community, and to his patients. Thank you.
Here are the exhibits. Move to adjourn the meeting. Instead of going to executive session.
Is there a second for that motion?
Second.
Any discussion? All in favor, say aye.
Aye.
Any opposed?
Don't know why.
We did this.
It must be just here.
Board's now back in open session. Dr. Jackson? The board had a unanimous vote and found you guilty on counts 1, 2, 4, and 5. And the recommendations are for your license to be suspended for 1 year, during which time you successfully complete a comprehensive psychosocial evaluation and a clinical competency evaluation at a board-approved facility. After successful completion of those evaluations, you may appear for possible reinstatement of your license. Psychosexual evaluation.
I'm sorry for the last part.
Let me read it one more time.
No, just the last
Okay.
5 words.
After successful completion of the evaluation, he may appear for possible reinstatement.
Yes, sir. Thank you.
Dr. Jackson, if your wish is to continue to practice medicine, I would hope that you take this potential education very seriously, and that on your re-presentation to the board, that we have a different interaction with you and a much more mature response of a rehabbed physician that is safe to practice medicine in Mississippi.
Hearing is adjourned.
Yes, we do. Moving on to other business concerning Sante Center for Healing.
Yeah, so at the last board meeting, the board had asked Scott Hamilton and myself to take a look at Sunday Center for Healing to develop a board approved course. That really mostly was Scott Hamilton looking at that, and he has determined that they are a qualified program that should be board approved. I'm correct on that, right? Don't want to be putting words in his mouth.
Do we need a vote for that approval?
I think we do need to vote to make it a board approved program. Yes.
Is there a motion to approve Sante Center for Healing as a Mississippi Medical Licensure Board approved course?
So moved.
Second.
Second, Kevin.
Any discussion? All in favor?
Aye.
Any nays? Motion carries. Is there any other business before I bring up another topic? We have a personnel issue that the board needs to go into executive session. Okay. Well, okay. I'm sorry. Let's move on to informational purposes. Terrence Hall, MD, Denton, Illinois, Mississippi Medical License 12605. It's a surrender of medical license dated October 29th, 2020. Do we need to formally approve this, or is this information?
It's informational only.
All right, back to, there is a personnel topic that we need to close the meeting and go into executive session. Would someone please entertain with a motion for that?
Make a motion that the board adjourn and go into executive session and discuss the personnel matter.
Is there a second?
Second.
Any discussion? All in favor? Any nays?
We're gonna set the meeting up later.
Ken and Stan
It's a line. You don't want to wait.
It's on
That's what
Sure, you got yours.
Back in open session. Next on our agenda is the dates for our next meeting in January 20th and 21st. Does anyone have any conflict with those dates?
Like right before the inauguration, is anybody going? Okay.
Is that gonna be a 2-dayer?
Yeah.
I've got my Clint White
I would
already.
count on it being a 2-dayer at this point. You know, these things tend to mature as we get closer to them, and it can bend down, but at this point, it would be a 2-dayer.
We have an invitation to the inauguration, we should cancel it. Presidential inauguration.
Yes.
22nd.
Yes.
Which inauguration?
Coronation.
Who knows?
All right, so can I get a motion to accept our dates for January 20th and 21st, 2021 as our next board meeting? Is there a second?
Second.
Any discussion? All in favor? Any nays? Motion carries. Thank you.
Good meeting.
We are adjourned.
Yeah. You did good.